right, the first case we're going to hear this morning is Goddard versus Burnett, and I guess Mr. Sasser, you're first.
May it please the court, I'm Travis Sasser. I represent Bobby Goddard. It was error to deny confirmation of Mr. Goddard's plan where he proposed to retain 3 vehicles and pay those claims through Chapter 13 trustee disbursements.
You're going to have to speak up. We're right across the room here, but you're talking down.
I apologize. Mr. Goddard was not in bad faith for merely doing what the bankruptcy code permitted him to do. These vehicle expenses are defined as reasonable and necessary under the bankruptcy code. There's a very high bar to finding bad faith. It requires that a finding that there was an abuse of the provisions, purposes, or spirit of the bankruptcy code.
And how would you define the spirit of the bankruptcy code?
I think it has to be defined based on the provisions of the code. So I don't think we can completely, I don't think this court should attempt to divorce the spirit from the provisions or the purposes. It's all one and the same.
Well, we defined the spirit in Dean's, didn't we?
Well, you did, but the idea at that time, of course, there was no 1325B either.
No, but that was the spirit. We defined the whole bankruptcy court. The idea it was to be used positively with the intent to try to pay off everybody. Well, I don't remember the exact language.
Actually, I think Dean's explicitly said that you didn't have to pay back everybody.
You don't have to pay back everybody. You have to have there's a spirit. You can't manipulate the bankruptcy court to.
I completely agree that manipulation or dishonesty would be a key factor in a good faith analysis.
Well, we're not involved with dishonesty here, but.
And I think that the issue, though, is if we're trying to figure out what the purposes or the spirit of it are, you look at the 2005 amendments to the code, and these are defined as reasonably necessary expenses. There's a number of reasons for the 05 amendments. One of them had to do with simply a mechanical formula where it was very efficient.
How is what happened here within the spirit and purpose of the bankruptcy code?
Well, because it complied with the provisions of the code, which says that the debtor is allowed to try to keep their vehicle.
And what about the manipulation part? This could not be viewed as manipulation when all the purchases were made within 33 months of filing bankruptcy, and he has 3 cars. He's one person, well, 2 people with 3 cars.
There was no.
Or does he have 4?
There was no finding of manipulation by the bankruptcy court. So if there was manipulation, it wasn't found that way. And again, he was simply just doing what the code allows him to do, which is to try to retain these vehicles. If the Congress had wanted to limit the vehicles, they certainly knew how to do it. And in fact, the code itself.
Let me ask you something. Yeah, if I understand your argument, you're basically urging us, based on the recent amendments to the code, that 1325B is a mechanical application. And if you comply with that mechanical application, then it makes no sense to conclude it's a bad faith under 1325A. That's what I think your argument is basically, isn't it?
It is, but I also I'm conceding the idea that you could try to manipulate that test.
Well, that's what I'm getting to. I was going to give you some hypotheticals under 1325B where the bankrupt abused it. For instance, the bankrupt says, I'm going to acquire 10 expensive oil paintings, and the way I'm going to acquire them, I can't afford them, but I can pay half. So what he does is he secures secured loans for half and unsecured loans for half, and then he says, I'll just go into bankruptcy, apply 1325B, get rid of the unsecured, and now I've paid for the secured, and I'll have these paintings at half price. Now, that sounds to me like an abuse of 1325B, right?
I think it would be an abuse under 1325A3.
Well, no, B. He followed B. He fought mechanically. I'm trying to get a hypothetical, right, which demonstrates that B can be abused.
I'm agreeing with you, actually.
Oh, okay.
I'm saying yes.
Yeah, okay.
1325A3 would come into play with any time there's a dishonesty or a manipulation.
This isn't dishonesty, manipulation.
Manipulation or abuse.
He's following the letter of the law. He looked at 1325B carefully and followed every step. And so you get something where he says, since I followed it exactly as Congress specified, I'm protected, I get that shield. And the argument would be, well, you can even abuse B. And if you abuse B, you can then apply A.
I do agree with that, Your Honor.
Okay,
I think that
okay.
we can't have, the judge has to maintain discretion in these kind of examples that you're giving, because otherwise the bankruptcy process will be abused. I'm simply just saying it doesn't apply in this case, because this case was a situation where I concede the point that the vehicles were purchased within about 30 months or so, but there was no evidence or findings that this was somehow a manipulation or an attempt.
And it's not just the vehicles, it's all the, nearly all the debt was accrued within the 33 months prior to filing bankruptcy.
I don't necessarily know that that's in the record. There was certainly a point made about the idea that there was a competition a bit between the secured debt and the unsecured debt, and that would be one of my arguments about the 2005.
I mean, it certainly looks like the argument could be made that there was a manipulation in that 33 months to carefully follow, as Judge Niemeyer says, the rule, and calculate it up to how much can I purchase to equate to zero or nothing left in disposable income, so I get the benefit of all of these cars and houses and fancy lawnmower without having to pay off the debt, which apparently he hasn't done at all for the last 2 years.
Well, there was no finding of that, and a very able trustee who was investigating the whole situation, obviously examining both at the 341
Well, what do
meeting.
you think it means when it wasn't done in good faith?
Well, I think that there's some different, we already, I don't want to beat a dead horse about manipulation and dishonesty, but certainly if there's situations where I think Judge Niemeyer's point is very well taken. Any kind of attempt to game the means test, I think, is very problematic.
But that's what, well, good, because I think so too. And I think perhaps this may have been an attempt to game the means test.
You said may have been, but there was no finding of that in the
Well, that's what
bankruptcy
both
court.
the bankruptcy judge and the district court found.
No, they
found 1325 bad faith, didn't they?
They did, and I would refer the court to the trustee's objection to confirmation, which simply says there's 3 vehicles, and therefore confirmation should be denied. There was no allegations of any kind of manipulation or planning or anything of that nature, which I think would be problematic. You were asking about other problems like a history of bankruptcy filings, an abusive way of interacting with non-bankruptcy litigation or perhaps even judgment collection. That has been in the past, and the district court pointed this out, that those can be examples of bad faith. So the bad faith requirement, or the provision, is still very much alive. However, on these facts, where somebody just simply has secured debt that they're using, that they purchased, I mean, I would point out that my client is a disabled veteran, and he's been through a lot, and he does enjoy that Corvette, and some people might say that's not necessary, but the Congress was very able to determine things that are luxuries, not necessary, things and they chose not to do that. And part of it was because
I don't understand how they chose not to do that. What do you mean?
In the statute, it does not have any limitation on secured debt, and I would refer the court to both the Bledsoe v. Cook holding that came out of this court.
No, but a court could conclude, you agreed with me, the court conclude that the following 1325B can be manipulative and abusive. And the question is, in this case, I gave you the hypothetical of 10 paintings where the guy intended to pay half for them and have the rest discharged. Here, we don't have that explicit, but we have that pretty much implied. He retained 3 expensive automobiles, and within a fairly short time, and even took unsecured debt shortly before he purchased the Genesis.
The Genesis was the newest of the vehicles.
Yeah, the newest,
and
right.
I would just point out, the part of the code is trying to do is they don't want to both require debtors to surrender their secured debt. This has to do with the fact that secured creditors are a big part of bankruptcy.
There's no requirement aspect. There's a question here of good faith. And the question of good faith is whether you follow the spirit. And the quote I was looking for is this. It says, Congress never intended that Chapter 13 serve as a haven for debtors who wish to receive a discharge of unsecured debts without making an honest effort to pay these debts and to pay those debts. And it seems to me the bankruptcy court clearly intends to give a new start, but they also intend that the debtor be totally candid, fair, and make some effort. Here he's designing a plan to take care of his debtors, creditors, and the district court found the plan to be in bad faith because it was manipulative. He's trying to retain these 3 expensive automobiles, vehicles.
Well, with respect, he didn't say, the district court judge did not say manipulative. He actually gave.
They say lack of good faith, right?
But oddly enough, none of the examples that the district court gave actually matched to the facts of this case. It was just basically a general assessment. So I think that, I see that I'm over time, but I would ask that the court give careful consideration to the Bloodsoe v. Cook, because, I mean, it really does almost answer this question completely, especially when you look at the fact that it relies so heavily on the Drummond v. Welsh holding out of the Ninth Circuit.
Can I ask you just one question? I know we are over time, but we received a stipulation from the parties that the debtor here is 8 months or 7 months or 8 months behind on his mortgage. Does that play any role?
I don't think so at all. We did that just to be above.
Well, it's clearly, it was not considered, but the question is, if the bankruptcy court receives that information, does that affect whether the plan will be approved?
The only thing I would say is if this court overrules the bankruptcy court, it is true that we will have to do a plan modification, which is a very common and customary thing that I'm sure that we'll be able to do.
So your position is it really does, it's just informational for us?
Informational only.
Yeah, okay, thank you. All right, Mr. Cook?
Good morning, judges of the Fourth Circuit. May it please the court. My name is Richard Cook, and I represent Amici Curiae, the National Association of Consumer Bankruptcy Attorneys, and the National Consumer Bankruptcy Rights Center. We are here in support of the appellant. Affirming the lower courts in this case will create a direct conflict with the holding of the Ninth Circuit in Drummond versus Welsh. In that particular case, the debtor, the Chapter 13 debtor, proposed to retain and pay the mortgage against their home, the car loan against 3 separate vehicles, loans against 2 ATVs, a loan against their Airstream trailer. And in that case, in Drummond versus Welsh in the Ninth Circuit was clear that the consideration of these secure debt payments, that the debtor retaining and maintaining these secure debt payments in accordance with the means test that was put in place in BAPSIPA, those secure debt payments in and of themselves cannot form the basis of bad faith. And so that's kind of what we have here with the lower court. The trustee's objection to confirmation was based on the debtor making these quote-unquote high car payments. You can see in the joint appendix.
But the court in Welsh did also say that a debtor may act in bad faith if he has unfairly manipulated the bankruptcy code, correct?
I think that is correct. And that's also where you can look at, you talk about manipulation, timing. Your example, Judge Niemeyer, of buying the paintings, you finance half, you put unsecured debts with the other half. In that situation, if that was done on the eve of filing, absolutely, that can be bad faith.
Well, okay, good. Here between December 2020 and November 2022, and it is all in the record, he purchased a $740,000 house. A month later, a Corvette for $46,000. After that, a truck for $62,000. After that, what do we have? A Genesis for $58,000. And then also accumulated $87,000 in unsecured debts on, including some personal loans. That's just in a couple years, and then files bankruptcy. That sounds like manipulation on the eve of bankruptcy filing to me.
I guess respectfully, I would say, Judge Thacker, 33 months, 30 months, we think that's actually quite a long period of time. I guess if it was in the record, which I don't think it is here, if the debtor had met with a bankruptcy attorney, say around this point of time, 30 months, 33 months, and there was this type of planning to kind of collude to manipulate the code, I'd kind of give that to you, but it's kind of a 2.5, 3-year period of accumulating debt. I would say that that's not uncommon.
It's a type of debt too. I mean, it's a Corvette, and justify the Corvette because it makes them feel good. I mean, we have a bunch of facts that were laid out, and while I understand your association's position to be that 1325B to some extent provides a safe haven if you follow that, it doesn't mean that that provision can't be abused. At least I think everybody would agree that it can be abused, and that 1325A is applicable throughout the code because that's the whole basis for the equity of the bankruptcy court. And I think this is a highly factual case, don't you think?
I do, Your Honor, but I also think, the fact, I guess the straw that broke the camel's back here is the amount of what these secured payments are. And this court was clear in Bledsoe versus Cook, a panel that you were on, Judge Thacker, that said that, and I kind of want to read verbatim here because I think this helps, that this is page 750 of Bledsoe versus Cook. It states, nothing in Clause 3, so Clause 3 is the part of the means test, 707B2, we call it Clause 3 in our brief. Nothing in Clause 3 suggests that there is any qualification or limitation on the kind of secured debt that is deducted from current monthly income.
But Bledsoe doesn't address the good faith requirement, the balancing, the good faith application.
Correct.
Right?
I mean, it basically all but went up to that line. Bledsoe versus Cook.
And what's the question in this case?
I mean, the question in this case is whether these secured debt payments on these 3 vehicles constitutes bad faith or is a lack of good faith.
And that was, as Judge Berner points out, that was not the question in Bledsoe.
Well, Bledsoe wholesale.
And as you point out, I was on that case, so I recall that was not the question in Bledsoe.
Correct, and I argue that one as well. The Bledsoe versus Cook wholesale adopted the reasoning of Drummond versus Welsh from the Ninth Circuit. And so basically, it did all but say good faith.
But I think you're overreading Welsh. I think Welsh was much narrower. I don't think Welsh suggests that compliance with 1325B provides a shield from any good faith analysis. And that's what the argument is being made here tends to be, that if you comply with the literal terms of 1325B, you can never be found to violate 1325A. And my suggestion in the hypothetical I gave to your colleague here was an abuse of 1325B, and he agreed that it could be abused. If that's so, then we get to the factual question, in this case, whether these circumstances reveal an abuse and justify the factual finding by the bankruptcy court and the district court.
Well, it seems the abuse that has occurred here is kind of the decision between the debtor to pay secured creditors versus not paying unsecured creditors. So basically,
Well, it's a combination of things. It's a question of the nature of the vehicles. It's the fact that it's 3 vehicles. It's the timing of the vehicles. It's the fact that these unsecured creditors are going to get a morsel out of this while he's going to end up with the ownership of these 3 vehicles, which he financed in part with these unsecured loans. I mean, it goes on, and the bankruptcy courts and the district court laid all this out. The question, I think, legitimately can be raised is 1325B a shield that if you comply with it mechanically, above median income type of situation, are you protected from bad faith? And we already have the concession, I think a necessary concession, that provision can be abused. And if it's abused, then we're in the good faith area.
No, I agree on that point, but I think what will happen here, we don't think this is an egregious case. I think this could lead to unintended consequences in that, one, you're going to have, because it's in the joint appendix that the payment the car payments being above the median number that is set by the IRS on the means test. Because these payments were over a certain threshold, it drew the objection from the trustee. And so median means it's in the middle, so conceivably more, half of these payments could be over that threshold. But the unintended consequence would be you're going to have expensive confirmation hearings that are going to be very fact-intensive. These are debtors that are already of limited means. But more importantly, we think it's going to disrupt secured credit markets, because the logical conclusion here would be you have to surrender one of the vehicles. You come into bankruptcy, and basically the bankruptcy judge is telling the debtor, you have to let...
You don't have to do anything specific. I mean, you keep suggesting that the code, a ruling that there's abuse, compels certain conduct. The burden is on the debtor to come in with a plan under that satisfies 1325B, and that is in good faith. And it follows the spirit of the bankruptcy court, which we articulated at some length in Dean's. And I think everybody shares what the spirit of the bankruptcy code is. In this case, based on the circumstances that Judge Thacker just laid out some of the scenario, the timeline on that, but the bankruptcy court was fully aware of that and recited it, and so did the district court. And so we have a question as whether that amounts to bad faith, and that to me is a legitimate argument, that whether that's bad faith. But I must say the indicators aren't really very good. This doesn't look like a man who's trying to get protection and make a good effort to pay his debtors. It looks to me like he's seeking a shield. But I may be wrong on that. But I think the position of your association would be, I guess, is to have maximum protection from 1330. If you comply with 1325B, to have maximum protection from that. You cannot, your position, I understand, should be or is, you cannot be in bad faith when you follow what Congress said.
Correct, Your Honor. I could not said it any better, Judge.
But Congress left in the good faith provision. It could have, at the same time, repealed the good faith provision, but yet the good faith provision remains. And we're here under abuse of discretion standard, and so it's your burden to show that the district court and the bankruptcy court abused its discretion. Perhaps there could have been could have gone a different way, but we need to review this factual finding for an abuse of discretion.
Well, we would respectfully state that if the lower courts misinterpret the law in making its determination, that would be a de novo review at this court, which, again, if you were to follow Drummond versus Welsh, where you exclude the calculation, the deductions for secured debts. Now, we're just talking about excluding the deductions. Now, again, when you talk about the circumstances for when you incurred the obligation, potentially the type of obligation, I think that would fall within it. But even Drummond versus Welsh pointed out that it somewhat cabins the inclusion of the means test in these mechanical deductions, does somewhat cabin the good faith discussion. However, just like in Dean's, it's pointed out, you definitely look to, was the debtor honest in its bankruptcy schedules? Has there been any fraud upon the court? You look at the prior bankruptcy filings of the debtor. Has there been a manipulation with those? Is there an attempt to defeat state court litigation? And then you look at other egregious circumstances. And so Drummond versus Walsh talks about that yes, it's slightly cabined, and I think that would also apply equally to this court's holding in Dean's. But
all right, I think we've covered this. We're over time here.
We respectfully request that the lower courts be vacated and this be sent back to the bankruptcy court. Thank you.
Yeah, all right. Mr. Burnett?
May it please the court. My name is Michael Burnett. I'm the Chapter 13 trustee for the Raleigh Division of the Eastern District of North Carolina. I'm the named appellee in this matter and the trustee for Mr. Goddard's bankruptcy case. The question before the court this morning is whether the bankruptcy court misapplied 1325A3 good faith or committed clear error in applying that standard when it denied confirmation of the debtor's Chapter 13 plan. And I'm asking the court to find that the court did neither of those. For two principal reasons. The first is that despite the debtor's completion of the means test under 1325B, the bankruptcy court still has the ability to consider the impact of that means test under a 1325A good faith analysis. And the second reason is even if this court accepts appellant's argument that 1325A3's good faith can have no relation to the means test in 1325B, nothing in the record of this case requires this court to reverse the bankruptcy court's denial of confirmation because the bankruptcy court provided a totality of circumstances analysis or factual findings, which remains a valid approach under Deans versus O'Donnell, and which is clearly not erroneous. So ultimately, under the facts of this case, considered with the plan as proposed, the debtor did not meet his burden of proof with respect to good faith. Now, as to the first reason, the 2005 revisions of the Bankruptcy Code, the Bankruptcy Abuse Provision and Consumer Protection Act, and with the court's permission, I'll just refer to that as BAP-CIPA. With the BAP-CIPA revisions, which were designed to address perceived abuse by debtors, it created a means test, and for above median income debtors, a highly formulaic and objective one. But it left the language of the original confirmation provisions of 1325A intact, and even supplemented those requirements with another good faith requirement in 1325A7 that the petition be filed in good faith. So weight must be given to that choice by Congress, that it left the 1325A A3 good faith requirement and the language intact, and it also proper weight must also be given to the fact that it created this means test for above median income debtors. And so through that process, the effect of BAP-CIPA, I think there's no question that the effect of BAP-CIPA was to reduce court oversight in calculating disposable monthly income for above median income debtors for the most part. Even with the strict statutory guidelines of the means test, there's still been, the Supreme Court, for example, in Lanning, was invited to hold to that mechanical approach, and it decided not to do that. It gave some leeway for calculating current monthly income. This court did it in Quigley, a case where a debtor was claiming expense deductions for secured debt he wasn't actually going to have.
Well, in Bledsoe, we did say that, quote, Congress made a conscious effort to cabin the discretion of bankruptcy judges by removing the power to determine what is or is not reasonably necessary. I mean, the opposing counsel could argue and did argue that we're inching too far into determining whether or not, for example, that Corvette was reasonably necessary in what the district court's ruling here.
And so I want to be very careful in responding to that, and that's a very good point. Good faith, I don't think good faith should be used to, as it has been used previously, in order to interject, for the court to interject itself into how the means test is calculated. Mm-hmm. It's very specific, and as opposing counsel pointed out, there are really no restrictions. When you're calculating the means test, a debtor can almost ad infinitum deduct whatever secured debt payments they may have. The argument I'm making here today is that unlike previous cases where courts maybe found issues with the means test because Social Security income wasn't included or IRA distributions or something of that nature, what I'm saying here today is the means test should stand alone. It deserves a particular independency, but so does good faith. And so previously the court was asking questions about manipulation. I think that we've got to accept the means test as it is, and the role of good faith is then to view what the debtor did with the means test. Even if they follow the strict letter of the law, look what the result of the means test is, and then determine how it interacts with the case based on the facts of that case. That fully respects everything Congress did with the means test, and it fully respects what Congress left intact with the 1325A3 good faith.
Well, if we adopt your construction of these two provisions, aren't we just running headlong into the Ninth Circuit opinion and creating a circuit split?
Yes, Your Honor. But the position that I'm arguing today is opposite of the Welsh, if you're referring to the Welsh opinion, the Welsh opinion. That is correct. Because
I'm not sure. Welsh is quite narrow, and I'm not sure it precludes a finding of manipulation of the means test.
And that's my argument today is that either Welsh should not be adopted in that sense by this court, or to the extent that it can be interpreted that way, it should be rejected. I think Your Honor was very correct previously in interpreting appellant's argument, and the argument is that as long as you satisfy the means test in accordance with the statute, then you by default satisfy the 1325A3.
Well, I think that's the way they read Welsh.
That's the way they read.
And I don't think Welsh goes that far. I think Welsh
Right.
addressed a much more specific circumstance and didn't preclude manipulation, abuse, and that type of thing.
But one of the reasons I made, reading the transcript of the confirmation hearing, one of the reasons I made such an issue of Welsh is because a number of other courts have interpreted it just as the appellants have, and I needed to draw out what is the proper interpretation, and not only the bankruptcy court, but in the circuit, how are we to take a case like Welsh and apply it? Because, as Your Honor pointed out, it would create, well, depending on how you interpret it, it could create a split. With regard to my first point, I think that both of these statutes can be respected fully in allowing A3, again, it's not an automatic means in order to challenge the means test, but the means test enjoys its independency, and the A3 good faith can come in based on the facts of a particular case. Otherwise,
And one of those facts being unfair manipulation, which Welsh says and left in place and acknowledged that the good faith requirement remains the same.
so the district court below did compare.
So I think Welsh is actually in Appellee's favor in that respect.
So I will say the Welsh factors for bad faith, in my view, are slightly different than the Deans versus O'Donnell factors.
You're not pushing back on what Judge Thacker just said, did you? Are you?
No, Your Honor, but if I understand Judge Thacker's point is that the Welsh.
Is that I think Welsh helps you.
That's what she just said, and you said no.
Well, oh, I'm sorry. I'm sorry. I misunderstood. Well, I'll won't push back against that, and I'll accept that. But the point I was going to make was the Welsh factors. The district court below found that the Welsh factors they're in line with the Deans.
It depends how you read Welsh, and I think you need to read Welsh carefully, because I think everybody seems to concede there are circumstances under which the means test could be applied manipulatively, in bad faith, and contrary to the spirit of the bankruptcy laws.
And I think that's my argument here today, Your Honor. Even though I will concede that the term manipulation has not previously been used up to this point, that is in essence what the bankruptcy court was implying below with its finding regarding good faith. And so, with regard to the first point, which I think is a question of law, I think those two factors stand independent and can still be applied even post-BAPSIPA, and to the extent that contrasts with the Welsh finding, I think it's a proper contrast. With regard to the second reason why I'm asking this court to uphold the bankruptcy court below, even if this court were to find that 1325A3 can have no relation in analyzing the result of the means test, I think the bankruptcy court below provided a totality of the circumstances analysis. It through the debtor's testimony and the evidence and record, it determined certain facts which, even though they might be tangential to the means test, they were separate enough to find that the debtor.
I think you couched that in a way that makes your burden much heavier. I don't think the argument is that 1325 cabins 1325B. I think 1325A relates to the entire plan. In other words, whatever the plan is, as you pointed out, 1325B stands on its own. And if you follow what it says, you're in compliance with it. That still doesn't make the plan in good faith necessarily if that means test, even though correctly followed, was manipulating the overall bankruptcy purpose.
I agree, Your Honor. The completion of the means test does not answer the question of whether or not the plan should be confirmed.
All right,
And-
and I think 25A, 3 talks about, basically is focusing on the whole plan, right?
It is.
Yeah.
That's right. There are 9 different confirmation requirements set out in 1325A. 7 of them are arguably somewhat ministerial, but there are the 2 good faith requirements. A3 with respect to the filing of the plan, and A7 with respect to the filing of the petition. And in this particular case, I think that the record is clear that the bankruptcy court, unlike courts in very similar postures and fact patterns and some of these other opinions, the bankruptcy court was not attacking the means test. It was looking at what the debtor was doing, his financial circumstances. There was discussion about his employment, the nature and amount of unsecured claims, unusual and exceptional problems facing that particular debtor. These are some of the dean's, non-exhaustive list, but some of the things that the dean's court mentioned, and the bankruptcy court went through the analysis and found, separate from any issues it may have subjectively with the means test, it found that the debtor did not meet their burden with respect to establishing good faith, and it is ultimately the debtor's burden to do that. And so I think that's a factual finding, and it's one that requires a clear error review, and I simply don't think that there's enough here in order to find that enough to remand or require or find that the bankruptcy court was improper in denying confirmation.
Anything further? Yeah,
I'm sorry, go ahead.
go ahead.
I was merely going to conclude, Your Honor, and say that, just to recap, this court need not take anything away from what Congress did under BAPSIPA with respect to devising a means test for above and median income debtors. And we fully respect that and the good faith requirement as it has historically been applied in this district. I think Deans versus Odell has aged very well in the past 40 years and is still fully applicable here today. And even after additional consideration, the court thinks that that is not correct. Even the Welsh court found that a totality of the circumstances analysis separate from the means test is still something that a court can use in order to deny confirmation. I believe that's what the bankruptcy court did here today, or excuse me, below. And for those reasons, I would ask the court to affirm the district court and the bankruptcy court below. And I'm happy. Any questions, Your Honor?
Thank you, Mr. Burnett. Mr. Sasser?
Thank you. I do disagree with the idea that Welsh doesn't already address it, or that Welsh is helpful to my opposing counsel. Welsh is extremely pertinent and helpful to our side because it very much anticipates the idea there will be secure debt payments that are absolutely allowed, even though perhaps not, even again, they're defined as reasonably necessary expenses. So there was no disposable income requirement under wage order bankruptcy from 1938 until 1984. Until 1984, there was no requirement related to these matters. So the idea that Deans was issued in 1982 and somehow set forth, and Deans is anticipating, if you read Deans and you read the footnote, it's saying we're waiting for Congress to do a fix. We're waiting.
We looked at Deans that described, I mentioned it to describe the purpose and spirit of the bankruptcy laws. And there are many, many other statements throughout the literature talking about the new start, the good faith. You come to the court with hat in hand, and you are getting a discharge, but you make your good faith effort to pay what debts you can, that type of thing under a plan. And so I don't think these generalized statements are necessarily eliminated with the recent amendments to the bankruptcy code.
You have to propose the plan in good faith and by no means forbidden by law. It doesn't say you have to make a good faith effort to repay your general unsecured claims. That's what the 2005 amendments were all about, was secured creditors are treated very well under that law, and that's a policy choice that the Congress made. I would refer the court to the Supreme Court holding in Ransom. It talks about the fact that it's a mechanical test. It's under-inclusive over and under, and that is what, that's the nature of a mechanical test, is it doesn't always produce results that maybe everybody fully understands, but the secured creditors are a big part of this, and also the efficiency and the uniformity. I mean, essentially what we're talking about is going back to a time when basically judges all over the country were just doing whatever they wanted in terms of the disposable income test. That is why the law changed in 2005. One of the reasons that it changed, both to prefer secured creditors and also to take the judicial discretion away. And I think what's going on here is we're saying somehow that provision means nothing because we're going to rely on some general spirit or purpose. I mean, the law has lots of purposes.
If you're right about that, why did they leave in 1325A?
To address situations of manipulation and dishonesty.
Okay, well, then you concede that B can be manipulated and can be the result of improper purposes.
But that's not what was found here.
Well, now, that's another issue. What was found here was bad faith or lack of good faith under 1325A3.
Because he had 3 vehicles, but not because he had engaged in any
Well,
manipulation
that's
or
too narrow.
dishonesty.
The court didn't just say because he relied on 3 vehicles.
That's what the objection was based on, and if you actually read what they say in the very end, that's the issue. There is, I mean, basically what the court, I know we're just here at oral argument, but you seem like you want to take us back to 2004 where you could just basically, the judges have total discretion about these matters, and the Congress very deliberately took that away. So I hope that the court will consider that.
Okay.
Thank you.
Mr. Sasser. We'll come down and greet counsel and then proceed on to the next case. Versus United States Center for Safe Sport. And Ms. Tucker, whenever you're ready, we'll hear from you.
Good morning, may it please the court. My name is Tamara Tucker from Charlottesville, Virginia, and I'm pleased to be here today on behalf of the appellants plaintiffs, Tom Navarro, Jim Giorgio, and Nina Schaefer. The principle that Congress cannot delegate away its vested powers exists to protect liberty. Our Constitution, by careful design, prescribes a process for making law, and within that process, there are many accountability checkpoints. It would dash the whole business, the whole scheme, if Congress could give its power away to an entity that is not constrained by those checkpoints. The Constitution's deliberative process was viewed by the framers as a valuable feature, not something to be lamented
You're arguing
and
that
evaded.
this is a government actor? Is that what you're?
There's
that
a non-delegation piece.
The non-delegation, basically, therefore, it's state acting.
Correct. There's overlap between the two concepts for sure. That quote was from Justice Alito in Amtrak 1, which is one of the quintessential non-delegation cases. He also goes on to say that one way the government can regulate without accountability is by passing off a congressional operation as an independent private concern. And given the incentive to regulate without saying so, everyone should pay close attention when Congress sponsors corporations that it specifically designates not to be agencies or establishments of the United States government. The United States Center for Safe Sport is exactly the type of entity, the private entity, that Justice Alito described. In the 2018 amendments to the Ted Stevens Olympic and Amateur Sports Act, Congress granted to the center, quote, exclusive jurisdiction to make rules, policy, investigate, and adjudicate the the conduct of millions of Americans, both in and outside of
What
sport.
would you have us do with the Supreme Court's opinion in San Francisco, Arts and Athletics?
That's very distinguishable from this case.
In what way?
Well,
I mean, if the U.S. Olympic and Paralympic Committee is not a state actor, how could we hold that Safe Sport is?
Well, for a number of reasons. Number one, the center was not in existence during the San Francisco Arts Athletics case. Number two, and more importantly, the center sits above the U.S. Olympic Committee. It does Congress's bidding. The statute is far more complex now than it was before from the 2018 and 2020 amendments. And the center is doing things that are well beyond the conduct and coordination of amateur sports. So in San Francisco Arts and Athletics, that's what they talked about. And we're not here because somebody's unhappy with a referee's call. We're not here over a trademark issue like in San Francisco. We're here because Congress has delegated to a private entity sweeping authority over millions of Americans. And the conduct that it regulates does not have to have a nexus to sport. It can be conduct, it can be me in this courtroom because I'm a member of USEF. I'm under the jurisdiction of the center as we speak, in addition to being under the jurisdiction of this court. And there's no oversight. So Congress has passed this sweeping legislation, giving the center rulemaking and policymaking authority, giving it enforcement authority.
What enforcement authority does it have, except for enforcing the rules of the game?
Well,
I mean, it basically says you can't be doping, you can't engage in sexual abuse, and we have all these problems in the Olympics that have shown up with sexual abuse and doping and other such things. That's really what is the purview, is to make amateur sports fair and moral. And San Francisco sort of said these are not core government functions. They granted that authority to this federally chartered corporation.
well, Congress has gone beyond that now. Congress has gone just beyond eligibility. That's for sure the change in status under the Fifth Amendment. But Congress has said—
Tell me what, be specific, what do you mean? It seems to me that they don't have subpoena power, they don't have enforcement power in the court except as private individuals. It seems to me they have the power to enforce their own membership, their own events, enforce the rules of the game.
Well, one way they enforce it is by putting your name on the World Wide Web, if you're a
I
barred
understand, but
individual.
that's their way of announcing. I mean, the idea that somebody could be competing who has been doping, it's part of that effort to make the game clean.
Well,
but the question I have is really, it doesn't look like Congress wanted to get involved in that.
Well, I
It looks
think
like Congress wanted to have the Olympic Committee and Safe Sport take care of that. Actually, Safe Sport was a spin-off initially of the Olympic Committee, wasn't it?
That's correct. It was organized and formed by the U.S. Olympic Committee, and then, spun off into its own board of directors. But rulemaking and policymaking are separate functions from enforcement authority. So enforcement
But the
authority is
enforcement is
executive.
still, it's not, if somebody didn't want to be subject to these rules, they just didn't have to engage in the games. In other words, these games it regulates members, it pays people engaged subject to amateur competitions. It's not regulating professional sports. And basically saying, you guys, not you guys, the corporations, set the rules and you can enforce the rules, but they don't enforce the rules by taking liberty and property apart from their membership. The only enforcement they have is to expel you and exclude you from games. That's the ultimate authority.
That is the ultimate action that they can take.
And they can
There's-
suspend you, and they can take away medals and things like this, but
Right.
this is all related to enforcing the rules of the game.
But they're not just enforcing the rules of the game because there's no nexus to sport. They're regulating people's conduct outside of sport and saying, because you did this, and, Ms. Tucker, you went to Thailand and you did something bad in Thailand, you're just not good enough to be a member now of
Well, it's
this
not that
organization.
general.
It is that general.
No, it seems to me if you did something that reflects your participation in the sport, if you started using drugs in Thailand, The question is, does that reflect on the sport? You're a member of sport team, organization, you're a member, it only regulates members and enforces rules. And now the question is the scope of a rule. Every sport talks about you can't be assaulting your wife and then still play sports. It's a bad image for the sport. But that doesn't make this a government action that is exclusively within the government. These are sport rules.
These are beyond sport rules. They are governing conduct. This is not field of play rules. This is not controlling the calendar, which is really what the Ted Stevens Act was designed to do, that Olympic NGBs would control the calendar, would set qualifying events. This is regulating conduct of a very personal, private nature in private settings.
Well, in this
such that-
case, we're talking about, at least in a couple of cases, we're talking about private conduct that's just simply unacceptable to sports competitors, right? You would agree? I don't want to go into the details of that.
Right. The private conduct occurred well before the sport code.
I know.
Right? And, could have been a factor in
But I
what
would
those
think
people chose
everybody
to
would
do.
agree that a person engaged in those conduct should be disqualified from the sport.
I don't necessarily agree with that. I think that I think that's why you have a hearing. I think that's why you have a hearing before you ban somebody without notice. I think there are factors that could be brought up in many of those cases and have been brought up in many of those cases. It's not an automatic decision. And that's exactly the point of having a pre-deprivation or a name-clearing hearing.
Well, you're in a competition and it has 4 rounds, and in the second round, they test the competitor and the person's doped. Do they have to have a hearing before excluding that person from the game? They
Yes.
don't. They exclude the person from the game in order to protect the sport, and then the person can challenge that, and does challenge it, and oftentimes takes a long time, a lot of levels. But the notion that you can't automatically exclude somebody from the game because of a violation, it doesn't make sense.
USADA gives a hearing before. So the Safe Sport Code has nothing to do with doping. USADA is the center, the private entity that deals with doping. And USADA follows the same model that the NGBs followed before the Safe Sport Code, which is you can impose temporary measures, you can run a B sample, and then you have your arbitration hearing before the determination of ineligibility. So it is absolutely not correct that you can test positive for doping and that you're automatically out and you can talk about it
Not
later.
automatically, but you can't automatically can eliminate them from the competition until they, it's tentative, but you can't have somebody competing who sexually abuses a competitor. He's a coach and he sexually abuses a competitor during the competition. You're going to let him continue?
That's why there are temporary measures, and we're not here on the interim measures. There's a big distinction between imposing an interim measure, and then there's a process for having a hearing after an interim measure. It's not what we're here about. We're talking about the final determinations that the center makes and the NGBs enforce, and they do it before a hearing.
In order to find an improper delegation, there needs to be some delegation of a governmental function or task. And I still haven't heard from you what exactly is the governmental function or task that you are arguing has been improperly delegated here. I heard you say that the names were posted on the World Wide Web. That doesn't seem to me necessarily a governmental function or task. What exactly are you arguing was improperly delegated?
Investigation power, adjudication power. The HISA cases they're exactly on point to your question, Your Honor. They say these are traditionally government powers. This is the legislative function. This is the executive function. I would direct your attention to the 2024 Fifth Circuit case on HISA after the FTC made the amendments and fixed the rulemaking part but didn't fix the enforcement part. Those are the governmental functions. Justice Thomas, also in his concurring opinion in Amtrak, talks about the fashioning binding rules as legislative in nature. And that's
But
what we
Amtrak
have
really
here.
focuses on the governmental nature of the particular industry. And I think in the context of sports and Olympic sports specifically, the Supreme Court's made clear that that's not the same.
I disagree. I think San Francisco talks about the conduct and coordination of sports, not investigating people, not, here's
But what is the conduct of sports and separate from who can participate? And how can there be a determination of who can participate if there's not some kind of
Here are some-
adjudication?
Here are some of the other changes that were brought about by the 2018 and 2020 amendments. They are instructed to investigate. They are instructed to work with law enforcement to investigate people. They adjudicate the conduct. They made all members of NGB mandatory federal reporters. So under the 1990 Victim of Child Abuse Act, that act traditionally is for professionals who work on federal land and in federal facilities. But now NGB members are subject to that act. There are federal criminal penalties. That's in the Safe Sport Act. It prohibits other members from transacting business with barred individuals, even outside of the context of Olympic sport. For example, I cannot take a riding lesson, from somebody who's been barred on my own private property, on my own horse, as an adult. I would be considered aiding and abetting and subject to penalties under the code. These are sweeping powers. This is not who is going to participate in sport today. This is more than that. And Your Honors, I see that my time is up. Thank you.
Yes, and rebuttal, right.
Yes.
All right. All right. Mr. Zonis?
Good morning. May it please the court. My name is Joe Zonis. I'm here on behalf of the defendants in the case. There's one crucial thing missing from plaintiff's case. The government. It's totally absent from plaintiff's case. There are no governmental actors here, and there's no delegation of governmental power. And as these are the prerequisites for plaintiff's claims, all of them, the claims fail. So, on the governmental actor front, to be clear, plaintiffs conceded in the district court that neither the United States Olympic and Paralympic Committee nor the United States Equestrian Federation are governmental actors. So they've already conceded that. So that leaves the question, as the court said below, of whether or not the center is a state actor. And for plaintiff Navarro, we already know the answer, because plaintiff Navarro arbitrated that issue. And at his arbitration, he argued that the center was a state actor, and the arbitrator determined that the center was not a state actor. And so, as the district court said, he's barred here from arguing that, based on res judicata. That res judicata finding is not appealed. For plaintiff Schaefer, the question was already waived, because plaintiff Schaefer chose not to arbitrate and chose not to raise that question in an arbitration, as she should have, and therefore she has no standing to make that argument here. So that leaves us with plaintiff Giorgio. And we start, and I think can end, with San Francisco Arts. Conduct and coordination of amateur athletics is not a traditional nor exclusive governmental function. Therefore, at the time, the United States Olympic Committee, now the United States Olympic and Paralympic Committee, is not a state actor. And the court went even further to say the ASA, the Amateur Sports Act, merely authorized the USOPC, or the USOC at the time, to coordinate activities that have always been performed by private entities. So since 1978, those entities, the USOPC and the national governing bodies, have had the power to do exactly what the center does now, and have had the power to draft the policies and the procedures to determine who can and cannot be eligible to participate in their private membership organizations, and have had the power to pull membership from individuals for whom eligibility was no longer proper.
What about, how do you respond to the arguments of your friend on the other side that the Safe Sport Act actually goes much further and allows the private entity or the quasi-private entity to regulate activity that goes beyond sports? Private, for example, equestrian lessons on private land, coordination with police, investigation, the list that she gave before she sat down. That does sound like activities that go far beyond participation in amateur sports?
Yeah, so a couple of different pieces there. I'll start with the broadest piece of that, which is, does Safe Sport look, when it's assessing, Safe Sport's mission is to assess fitness to participate in sport, as it says in the code. And when assessing fitness to participate in sport, does the center look at activities outside of sport? Absolutely. So, for example,
Well, her argument isn't that, she also says that, but my question is not about what it looks at to determine whether somebody is fit to participate. My question is whether the reach of the authority of the organization extends beyond participation in amateur sports and actually controls individuals' participation in society in other realms.
no, I mean, the most that the center can do is say, you can't be a member. You can no longer participate in our private organization over here. They can still, for example, her clients can, and I believe do, train individuals in equestrian sports. You can own horses. You can do, you just can't do it with the 5 rings above your head anymore. That's all the limitation is. And so much like the court said in NCAA with Tarkanian, said UNLV, you can drop out of the NCAA. You don't have to be a member of the NCAA. If you don't want to be bound by these rules, bail. And the same could attain here, which is if our clients do not want to be bound by the rules of fair play and the rules of safe sport, they need not be members of these organizations. It does not impact whether or not they can still ride horses, for example, or swim or any of the other sports.
Or they could still gamble. I mean, if they were found to gamble and then disqualified, they could still gamble as long as there would be maybe laws relating to that, but
100%. And to take your doping, it is true that the Safe Sport doesn't handle doping, that USADA handles doping. But to take your doping example, Your Honor, in the doping example, you can dope all you want if you're not in the Olympics. Go ahead. Plenty of actors do it to look really good for their movies. So you're allowed to dope. You just can't dope with the 5 rings over your head. That's all.
and the Pan American Games and a few other things, right?
Correct. These private organizations had the power to determine their membership. They had the power, for example, Your Honor, to run a criminal background check, still have this power themselves. And if the criminal background check popped something that gave them concern, they could ban someone from participating in their member organization. In 2017, the center was formed because these organizations came to a conclusion, given what I think we all know how things were going in the movement at the time, that this needed to be a centralized organization among these 50 private entities. It needed to be centralized and focused on the welfare of athletes in sport, and particularly minor athletes in sport, and hence the creation of this U.S. Center for Safe Sport. And prior to any legislation, Safe Sport operated for a year. Created its rules, all under private agreements, and because the bylaws of these individual private organizations said, we're going to allow Safe Sport to do this. And so it was all under private agreement. And all Congress really did when they came in with the Safe Sport Act was say, okay, USOPC and the national governing bodies, you used to do this. We understand that you want the center to do this, and we also agree with you that that's a good idea. And so we're gonna bless that. It did not give the center any subpoena power. Congress did not give the center any other governmental powers. Unlike the HISA cases, there's no subpoena power, no ability to levy taxes, no ability to execute searches on private land, no way to levy fines. In fact, the center cannot even enforce its own decisions. The national governing bodies enforce those decisions through their private agreements with their membership. The center has none of these powers, none of these governmental powers, nor any power to enforce its own decisions. And at most, all it can do is say, hey, national governing body, this person can no longer be a member of your national governing body. They can go do whatever sports they want, just not with the 5 rings above their head. As far as the due process arguments, at the heart of these claims is this denial of a predetermination hearing. I'll just briefly address that to say that the center is obviously not a state actor. There is no requirement for a predetermination hearing. And as Your Honor was discussing earlier, there is frankly no time. And it is an example that I put in the brief, which is if the center has allegations that someone's engaging in inappropriate behavior, for example, a coach with a minor, and that coach is about to get on an airplane, the center's not going to wait around for when they get back to give them a hearing before they bar that person from sport and prevent them from getting on that plane with that minor. That's the center's mission. And to suggest that the center should wait around to do the hearing first, I think I'm not going to weigh in on that. The center has no obligation to provide that hearing beforehand, and more importantly, the center provides these hearings fairly quickly afterwards. So the process comes when it is due. As far as I'll touch on the two other issues before you, which is the Ms. Schaefer's arbitration. Under the Safe Sport Code, arbitration is the sole and exclusive method to resolve any challenge to the center's eligibility decisions or its processes. Here, Ms. Schaefer is attempting to argue that the center does not provide due process in its processes. That is something that she was required to arbitrate in the first instance, as Mr. Navarro did in his arbitration. She failed to do so. Here, Ms. Schaefer argues that she's excused from arbitrating issues regarding statutory construction and excused from arbitrating issues of constitutionality. This very circuit has in McDonald said that statutory interpretation does not justify bypassing arbitration, and in Nations Bank that constitutional claims are not exhausted, are not exempt from exhaustion requirements. So the court's decision that Ms. Schaefer failed to exhaust her administrative remedies and her claims are therefore barred should likely be affirmed. And finally, the USOPC standing issues. The district court concluded that plaintiffs failed to allege any causation or redressability. I think as the district court found that it's true. They did not allege that the USOPC had any role in the eligibility decision. It didn't. Did not allege that the USOPC had any role in imposing the sanctions. It didn't. Did not allege that the USOPC published their names. It didn't. Those were all acts taken by the center, nor did they allege that the USOPC had any involvement in enforcing the sanctions. Again, USOPC didn't. Those were enforced by the U.S. Equestrian Federation. Congress noted that it's unclear in this instance what the USOPC could have done on the redressability front. The USOPC has no power to do anything in those circumstances, particularly now under the new legislation, which prohibits it from interfering in the center's operations.
All right.
Thank you very much.
Mr. Koppel.
Good morning, Your Honors. May it please the Court. I'm Josh Koppel for the United States. I want to start with plaintiff's private non-delegation claim. That claim fails at step one because Safe Sport isn't exercising governmental power. The U.S. Olympic and Paralympic Committee created Safe Sport on its own without governmental direction to coordinate oversight and response to the problem of abuse in amateur sports affiliated with the Olympic movement. Congress recognized and memorialized Safe Sport's functions a few years later. But that doesn't change the fact that Safe Sport is fundamentally a private actor and is not exercising government power. The Supreme Court recognized in San Francisco Arts and Athletics that the coordination and conduct of amateur sports is a private function, not a governmental one, and neither is the development of policies related to the prevention of abuse within a private organization. Many private organizations have policies and procedures to deal with abuse. Many of those will recognize conduct that occurs outside of the organization because it identifies the type of person or people that they don't want within their organization, and they will exclude the person from their organization on that basis.
But
and that is all the Safe Sport is doing.
In those circumstances, are there statutes that codify those rules as essentially mandates or binding? Is there any other statute like this one, like the Safe Amateur Sports Act? Is this unique?
I'm not sure if there are others like that. There are other statutes that recognize not conduct standards, but other kinds of standards developed by private organizations. For instance, there are statutes that recognize.
But this is the not recognizing standards developed by private organization. This has actually the procedure and the standards set forth at length and in detail articulated. And then, in fact, there's a provision that says the policies and procedures developed under the subsection shall apply as though they were incorporated in and made part of the act. And so it does seem to be a different kind of statute than anything else, at least that I'm aware of.
So the act does not say private individuals must comply with the policies and procedures developed by Safe Sport. What it does is it says it references section 22524, which is the general duties of national governing bodies. So in that section, Congress has regulated the national governing bodies that are authorized to represent the United States in international competition. And it says one more obligation of the national governing bodies is they have to agree to abide by the Safe Sport policies and procedures if they want to be a national governing body. If USEF decides it doesn't want to abide by the procedures of Safe Sport, it doesn't have to. The U.S. Olympic Committee simply won't recognize it anymore as a national governing body authorized to send individuals to the Olympics. But USEF can continue to organize amateur athletic sports. And there are organizations, amateur athletic organizations, that don't abide by Safe Sports policies and procedures. They organize sports. They're just not recognized as national governing bodies. They don't choose who to nominate to go to the Olympics or other international competitions. And when Safe Sport sanctions an individual, the sanction is, again, you can't compete with the national governing body. But that individual can compete with other athletic leagues, can train individuals outside of the parameters of the national governing body and the Olympic movement. And so in that way, what Safe Sport is doing is fundamentally a private function. It's regulating who can be within this private organization. It's not there's no criminal liability, there's no civil liability, and that's what really distinguishes this, for example, from the HISA cases.
And if Safe Sport oversaw a different kind of entity that wasn't amateur sports, I take your argument to be that because this is amateur sports, it's not a governmental function. If it was, for example, overseeing who can fly up an airplane or who can drive a train, then that might be a governmental function, and there could be potentially a non-delegation issue there.
No, I don't think that it is, that the problem is that it's just, I don't think that the distinction is that this is amateur sports as opposed to something else. I think the distinction is that it's regulating conduct within a private organization. There's no civil and criminal liability for violating Safe Sports policies and procedures. You're not excluded from the entire industry. You're just excluded from the private organization, which what the Supreme Court has recognized continues to be a private organization.
Well, I think your colleague on the other side says this is like Amtrak.
So
why is it not like Amtrak?
Congress set up Safe Sport, set up the U.S. Olympic Committee as an independent corporation. The Supreme Court recognized that the U.S. Olympic Committee continues to be a private actor, and the U.S. Olympic Committee then on its own created Safe Sport as an independent body to govern, to create policies and procedures to deal with abuse. Those policies and procedures continue to be private policies and procedures even after Congress has recognized and memorialized Safe Sport's role. Safe Sport's, the sanctions that Safe Sport can impose are no different now than they were in 2017 before the amendments to the Amateur Sports Act. They continue to simply be exclusion from the private organization, that the national governing bodies and the U.S. Olympic Committee. Just very quickly on the issue of the due process claim, the due process clause, of course, protects individuals only from governmental action, not from private action. Safe Sport's a private as we discussed, Safe Sport's a private entity that doesn't exercise any governmental function, and the government has not coerced Safe Sport into not giving a pre-deprivation hearing. Safe Sport on its own determines whether it wants to give a hearing before or after it imposes a sanction. And so the choice not to give a pre-deprivation hearing in these circumstances can only be attributed to Safe Sport. It can't be attributed to the government. And so there is no due process violation. Happy to answer any other questions. Otherwise, we ask that the court affirm the decision below.
Thank you, Mr. Kopp. All right, Ms. Tucker, you have some rebuttal.
Thank you, Your Honor. I want to take this point by point. First, we haven't discussed count 5, which is a facial challenge to the statute under the Due Process Clause. Congress is a state actor, obviously. So when Congress passes a statute that on its face violates a person's due process rights, it's unconstitutional. And in this case...
Well, that's pretty broad. What about the National Bank Act? I mean, we charter banks, private banks all across the country.
Here's how they violate, here's how it's facially invalid. Congress has mandated that when the center makes a decision to bar an individual, and I'm not talking again about temporary measures, we keep hearing the airplane example, that's got nothing to do with this case. When Congress bars somebody and makes them ineligible permanently or for a period of time, when the center does that, Congress has said their name goes on the World Wide Web. That is the wall of shame. It is stigmatic. It is a liberty interest. The change in status is the stigma plus. Congress has not required...
You know that when you become a member. In other words, the idea, part of enforcing exclusion from the sport is to make sure that the person who has been excluded doesn't re-engage in the sport in some context where they don't know about it. And
Your Honor, respectfully...
I mean, maybe you could sue them for defamation of torts, but that's not state action.
Well, you don't need state action because you have Congress that's passed a statute that has said
It just
deprive these
authorizes
people...
the corporation. It's a
deprive these
state-chartered
people-
corporation, a federally chartered corporation that charters a private corporation and tells them to make the rules, and tells them to enforce the rules, and the ultimate sanction is exclusion from the sport.
That's not what's happening. Congress has directed the center to put their names on the wall and change their status, and has not told the center to give a pre-deprivation hearing. Leaving it up to the center, as my colleague just argued, makes it worse, not better. Leaving it up to the center is not the way to fix the facially invalid statute. Congress
Well,
needs...
leaving it up to the center undercuts your delegation argument.
No, I don't think it does. This is kind of one of those rare things. Normally, there is sort of a conflict between the Fifth Amendment and non-delegation. It's a little bit of an either-or. This is one of those situations where, as my colleague just said, Congress blessed this arrangement. Congress came in after the fact and said, hey, this is great, and then it added a bunch of stuff that I listed earlier. With regard to the subpoena power, that's irrelevant. The EEOC doesn't have subpoena power. It's governmental, clearly governmental. So that's kind of a red herring. And I think it's important to remember, to Judge Niemeyer's point, that when Congress blessed this arrangement, Congress also granted civil immunity to the center. So, you know, on the one hand, it has no governmental oversight. On the other hand, it's offering significant governmental protection, and it's offering significant governmental mandates that I listed earlier. And so it's almost as if, in this case, they wrote the worst possible statute, where they went too far in some ways and not far enough in another. But here's how it works. Either there's oversight or there's a pre-deprivation hearing. It's not hard to fix this. But for whatever reason, 7 years down the road, we can't seem to get this fixed. I would also mention that with regard to my colleague's comments that my clients can still teach riding, again, they cannot teach on private land to people who are members of USEF.
When you say they can't,
Right.
the sanction for everything is membership. The sanction isn't a criminal or civil sanction. There is no civil. Basically, it's a rule that leads, ultimately, the most severe sanction that they can impose is exclusion of membership.
Well, they don't teach. They're severely limited in their employment now because people who take lessons from them, who happen to be members of USEF, will be liable potentially for aiding and abetting. So this notion of, oh, we're just not under the 5 rings anymore, but everything else is hunky-dory, is simply not the case. And in fact, the center extends sanctions and interim measures and other types of punishments
Well, if persons
on
don't
private
want to
land.
be members and don't intend to participate in the Olympic movement or the Pan American Games or whatever these national games that involve the membership, they don't have to belong. And they can do whatever they want, I mean, in this regard. The idea is people do want that membership because they do want to have the participation or the potential participation in the activities that lead to participation in the Olympic Games. But I don't understand the argument that all of this is government action simply when the ultimate sanction is exclusion of membership from a private corporation.
Your Honor, that's premised on some factual misunderstandings. So this is not simply prospective in nature. This statute was not passed on a prospective basis, as was HISA. HISA, Congress specifically said, look, you're going to investigate and adjudicate and do all of these things, you being the authority, and you're going to do it on a prospective basis. This conduct has been investigated going back to long before when somebody signed up their membership agreement, there was a safe sport code.
Let's take just a hypothetical. If it is private, you have your private poker club, and all of a sudden you decide you don't want a member of the club because one member was 10 years ago engaged in embezzlement, and you say he's out. The club says he's out because we don't want somebody who engaged in embezzlement. Now, where the courts come in and say the poker club can't do that?
Well, because if Congress writes a statute that says, hey, the Poker Enforcement Embezzlement Center is now in charge of the poker club and gets to write the rules for the poker club and tell the poker club what participants can and cannot be in there.
The poker club already is making its rules.
Right, but
And it
then
does
why did Congress act? So that's the problem here. Congress stepped in it. Congress waded into this area of regulation well beyond what it had ever done before. It's a lengthy statute. To Judge Berner's point, it is a statute like no other. That's why we're here, because there is no other statute that anyone can find that does what this one does. It has not simply said, oh, you're the National Veterans War thing and you can have your bylaws and go forth and you're a patriotic organization. I'm sorry, may I finish my answer?
30 seconds.
It goes well beyond that. If you look at the length and breadth of the entire Safe Sport Act, those 2 amendments, you will see that this is not simply Congress, letting the poker club decide who's going to be in the poker club.
Okay.
Thank you.
Thank you. We'll take a short recess to come down and greet counsel.
This honorable court will take a brief recess.
Next case we'll hear this morning is Doe versus Office of the Director of National Intelligence, and we'll hear from, I guess, Ms. Utrecht.
Good morning, Your Honor. Jennifer Utrecht on behalf of the government. Your Honor, in Webster versus Doe, the Supreme Court held that the National Security Act commits to the director of CIA and ODNI's discretion the decision to terminate agency employment. That's a decision that is committed to discretion by law, and it precludes district court jurisdiction over ordinary APA claims, including claims that agency violated its own regulations. Notwithstanding this, the district court here has enjoined the directors from effectuating the termination of CIA and ODNI employees, concluding that plaintiffs were likely to succeed on the merits of their claim that the agency failed to follow procedures set forth in internal agency regulations. There are two problems with the district court's reasoning here. The first is that the district court fundamentally erred in transforming an ordinary APA claim into a constitutional one. And the second is that the district court fundamentally misconstrued the regulations on which it relied. Those are related problems, so I think I would like to start with the text of the regulation itself.
It seems to me that it was the agency itself that transformed what happened here, because the agency executed a reduction in force and then decided, no, that's not what we're doing. We're terminating all these people under our broad authority. And that decision wasn't made until after the lawsuit was filed, ironically.
So respectfully, Your Honor, I believe in the JA itself, there's a letter from, both a letter and a declaration from the director stating that he had made a determination.
Right, then that was after the lawsuit was filed. The initial memos talk about a reduction in force, don't they?
So
I know the declaration you're talking about.
but there is
memo.
also a memo that says that the director has deemed it necessary or advisable in the interest of the United States. And
is that the January 23rd memo?
Yes, ma'am.
Okay.
Yes, Your
All right. And also, that's after the prior memos that that indicated this was a reduction in force consistent with the OPM.
So I think it would be helpful, Your Honor, to take a step back here, because the question of whether this is a reduction in force or not is really irrelevant. And the reason for that is because, as the Supreme Court said in Webster, when the director makes the determination, when the director deems it necessary or advisable in the interest of the United States, that is an unreviewable decision. And second, I would also note, I mean, I would like to point to the regulation itself, if we can.
But that's not what the director said when he initiated the reduction in force consistent with the president's executive order.
To be clear, Your Honor, plaintiffs have not disputed here that the director did indeed deem it to be necessary or advisable in the interests of the United States pursuant to his authority under the National Security Act, the termination of plaintiff's employment, that it was necessary or advisable. That is not a disputed fact here. And so what we're left with is the district court's reasoning that, well, the only reason, the motivation that the director had was that the president had closed these offices and said that these employees should be terminated. And I don't.
But wasn't that the motivation?
So first of all, Your Honor, I think the fact that the president has advised or provided his own opinions to the directors doesn't change the fact that this was an independent decision made by the directors, that it is
The
still.
memo says it was the initial memo says it was as a result of the executive order. The declaration probably says that too.
So absolutely, Your Honor. I mean, so that doesn't.
I guess what I'm hearing is the director can just rewrite history anytime he wants. And here it was after the lawsuit was filed. He decided to suddenly make a declaration that he did something he clearly did not.
So I would
Under
direct
oath.
Your Honor to page 73 of the joint appendix, February 18th, 2025. This is the memorandum that was sent out directing these employees to receive the notices that they did.
What
On page
date was
73,
that?
it says.
What date was that?
February 18th, 2025.
When was the lawsuit filed? The day before.
Was it?
Yes.
So
So back to my question, the director can just rewrite history after the lawsuit's filed.
So, and then the second point.
Is that?
The second point
Can
I
the
would like
director
to
just
make.
can the director do that? just make up a new reason after the lawsuit's filed?
Your Honor, the second thing that I would like to point to,
Well, you can say the second thing after you answer my question.
I don't think it's rewriting history, Your Honor. They're just the
Well,
fact that
did-
there wasn't a public
Did
record
the first
of-
memos, what did the first memos say? Did they say reduction in force? Do you want to see
I
them?
don't believe there's anything that said reduction in force, Your Honor.
Okay.
If you could point
Well,
me to it,
I
would.
will. Go ahead with your second thing you wanted to say.
Okay, so second of all, Your Honor, and again, I'd like to look to the text of the regulation itself. So to have a protected property interest under the Constitution, there has to be some source of positive law that gives plaintiffs an independent substantive right that limits discretion in some way. The regulation on which the district court relied several times disclaims any such property interest. So we're looking at 2A of the regulation. So it
Okay,
says,
so the January 21st memo from the director, where the director's directing people on what to do, says on page 2 of it,
which page of the JA is this, Your Honor?
it's the, I'm not looking at a JA site right now, but I'll find it. It's the January 21st, 2025 memo from Edsel, acting director. and
Oh,
it
Your Honor,
says-
that's not from the director of the CIA. That is an OPM memorandum.
All right, but the declaration refers back to the OPM memorandum, doesn't it?
Absolutely, Your Honor. The director said, although the director doesn't have to provide his reasons for why he deemed it to be necessary and advisable in the interests of the United States, he said that his decision, his discretionary decision, was informed by the president and the OPM memorandum. Now, of course, the fact that he received advice.
Informed by and yet at odds with the OPM memorandum.
Well, I think it would be helpful to just clarify. The OPM memorandum was provided to all agencies across the government, including agencies who are subject to the Civil Service Reform Act protections, which CIA employees are not. And so there is a separate set of statutory guidance and regulatory guidance as to how to conduct a reduction in force in those agencies. There is no such equivalent statutory protections for CIA employees. And so really the OPM memorandum doesn't have any actual effect here. What does have, and I would remind this court, that what the district court's reasoning here was that the CIA's own regulations required some sort of reassignment in these circumstances. And again, I would point, Your Honors, to several times throughout those regulations.
But those regulations don't apply if it's
Correct.
the decision of the director.
Not only do they not apply if it's the decision of the director, several times, I'm quoting from section 2A, it says, agency employees do not have tenure and their employment may be terminated without regard to the procedural requirements of this regulation. They are non-binding steps that do not bind the agency. They do not create a property interest of the type that's protected by the United States Constitution. And
So the declaration then at JA 148 says, I understand that these directives, those in the OPM memo and apparently the executive order from the president, because that's cited in that same paragraph, in combination effectively terminating the employment of these employees. Therefore, I decide to do the opposite and terminate these employees.
so again, Your Honor, I think that question is really getting into whether it was an abuse of the director's discretion to terminate these, to deem it necessary or advisable in the
But
interest of the United States.
did I read, am I understanding that correctly, that the director acknowledged that the OPM memo and the executive order in combination prescribed, scribed, terminating the employment of the employees?
So
That's what it says on paragraph 3.
again, so on page 73 of the JA, which is the memorandum, it says that he's making the decision to terminate them because he's deemed it to be necessary and advisable in the interest of the United States to best effectuate the
And that's the
president's
February
direction.
18th
That's the
memo,
February
right?
18th. And then the declaration, let me just pull up the exact page, I'm sorry.
It's JA 148.
JA 148. What JA 148 says is that these offices have been closed pursuant to the executive order, that OPM has provided guidance on to how to conduct
And
reductions
the
in
guidance
force.
was, reductions in force.
And that, yes, it says that these directives in combination effectively prescribe terminating the employment. That's correct.
But what's lost in that sequence is that while the president made some directives, and OPM made some instructions how to do it to the various agencies. When each agency is carrying those out, they have their own criteria.
Absolutely.
And Congress was very careful to make sure that the CIA director could terminate somebody even on a hunch or for no reason or for all reasons.
Correct.
The idea he suspects somebody's a mole, he doesn't have to say a thing, there's no process, he can get rid of them. And we've litigated that before.
That is absolutely correct,
And
Your
it's
Honor.
just applicable to the intelligence agencies
Yes.
for a lot of good reasons that Congress found. So when it comes to these two agencies, the director had absolute authority, unreviewable authority to terminate.
That's correct.
When it comes to another agency, they may have to follow RIF rules. And maybe there's another agencies that you have other rules that are applicable. But in this case, there's simply no, if a lower level CIA person terminates somebody, they can appeal to the director. If, say, a lower level supervisor says somebody's being terminated for something, theft or whatever it is, that employee can appeal to the director. But whatever the director says, Congress wants him to have that absolute authority. And I don't know how a court has any constitutional authority, statutory or constitutional, to review the director's decision to terminate people.
I agree.
He can terminate half the staff if he wants.
And to add on to that, Your Honor, I agree with everything that you said. I mean, Congress has vested this in the...
But you haven't emphasized the fact that the director has that congressional authority from Congress.
The reason that I haven't been emphasizing it, Your Honor, is because the district court itself recognized that. That's not, we're not disputing the fact.
The district court was concerned about AR, what number is it?
416?
416, that provides for procedures for termination of excess personnel. And what the district court said is if you have a procedure, you have to follow it. And what the district court found, as a matter of fact, and we defer to findings of fact of district courts, particularly when we're here on abuse of discretion standard of review in a preliminary injunction context, the district court said, I find this was a reduction in force based on the facts that are presented to me. And so if it is a reduction in force, then there is a provision in the regulation that provides for termination of excess personnel and for a procedure for an appeal. And so that's what the district court found. Under Arcadi, the procedures, if they exist, need to be followed.
And as the response to that, Your Honor, I mean, starting with the preposition that the director's decision as a statutory matter is committed to his discretion, and the motivation...
When discretion is being exercised. But here what the district court found as a factual matter is this wasn't a discretionary decision. It was a RIF.
So, Your Honor, again, the...
Why don't you point out that the procedure is a procedure to apply to the director?
So, yes.
That's the only procedure, and if the director made the decision, there's no procedure for him to review his own
Yes, Your Honor.
decision.
So my first response to that question is, Webster tells us the motivations of the director do not matter. When the director makes the decision, as a statutory matter, it's committed to his discretion. And as to the regulations, the district court fundamentally, and this is not a fact finding, this is a question of law, the district court fundamentally misconstrued the regulation. The regulation itself says that agencies can be fired for any reason without regard to these procedures. Section 2D says when the director makes the decision to deem it necessary or advisable in the interests of the United States, that he may do so without regard to any of the procedural steps in this regulation, and that those employees may be fired without regard to any of the...
And he doesn't have to say why he deems it in the interest of the United States to fire everybody in the diversity, equity, and inclusion.
The regulation does not require any explanation to be given. And again, I'm quoting from the regulation here. This is on page 62. It is not required that an employment termination under the statute be in the interest of national security, but only that the director in his discretion deem it to be in the interests of the United States. It then goes on to say that the director need not provide the reasons, that this is entirely discretionary.
But if the director does provide the reasons, that's what happened here. There was a change in, essentially, reading the documents. Initially, there was a reason provided, and the reason provided was to eliminate an entire section and declare these employees excess to the needs of the career civil service, which is exactly what the regulation provides. I actually have a different question, if I may. I'm wondering what's the status of the terminations now? Has the injunction been complied with?
So the injunction just prohibits us from effectuating the terminations.
Well, the injunction also requires that the individuals be provided an appeal.
Before they are terminated.
An appeal process.
Right, but there has been no procedure because we have elected to pursue this appeal rather than to moot out the case.
Was the injunction stayed pending appeal?
We did not request a stay, and part of the reason for that, Your Honor, is because all of the employees who were affected by this decision were afforded options, including taking the deferred resignation. Many of them would not have had an end date of employment until September, and so there was no urgency when this appeal was first filed.
So even though the order specifically says it is further ordered that the defendants provide plaintiffs a requested appeal from any decision to terminate, there was no, in fact, no provision of an appeal.
The injunction says that we cannot fire anyone until those procedures are complied with, and we have not fired everyone. Everyone affected by the injunction
I don't
remains
know why
on
you don't
leave.
get to the fundamental question. It seems to me that the procedure the district court was focusing on is when somebody is terminated, they have a right to appeal to the director, and the director's decision is final and appealable. And that's the only procedure. There's no appeal when the director makes the decision.
I agree,
The
Your Honor.
regulation doesn't provide that.
I agree, Your Honor.
Well,
And
you
I-
haven't said that.
I think I've said that.
And that's
I'm
the
sorry
problem
if I
with the
haven't-
district court's order.
I think I've said that a couple of times. I'm sorry if I haven't said it clear enough, Your Honor. The fundamental problem with the district court's order, and again, the question of whether this is effectively a reduction of force doesn't matter, because under
It
Section 2D...
doesn't matter whether it's a reduction of force, whether the president ordered it, whether he liked to do it, or whatever reason. Congress gave the intelligence agency directors absolute authority to get rid of employees.
Right.
And there are a lot of good reasons for that in the intelligence community. And he's unanswerable, and Congress has made him unanswerable.
Absolutely.
Now, if a lower-level employee terminates somebody at the CIA, there is a right to appeal. There is a procedure that goes to the director.
That's
But
right.
the director is the end of the line.
Right.
And in this case, the director made the decision, and there's no appeal from that.
Correct. I've been focused on the
So
regulation
the
because...
idea that there's an order for appeal, it's nonsensical because he has to appeal to himself.
Absolutely, Your Honor. I mean, I've been focused on the regulation as a whole because the district court found that this right was found in the regulation, but the regulation itself, and I'd also note that this was at issue on remand in Webster itself, when the Supreme Court said that there was a constitutional claim that could proceed. The D.C. Circuit, in that case, looking at a fundamentally identical regulation, an earlier version, said these procedures for the various steps that are taken apply in the ordinary course when lower-level officials are making decisions. But as a whole, the regulation makes abundantly clear that when the director has made the determination, it has deemed it necessary or advisable in the interests of the United States, that none of the procedures apply, that none of the procedures have to be complied with. That's in Section 2A, it's in Section 2D, it's in Section 2F, it is
And the
repeated.
procedures not only don't have to be complied with, it's
They don't make any-
nonsensical to make it apply,
that's
but
correct, because the
there's
appeal-
also no appeal from it.
The appeal, so for example, the Section 2E, which the district court discussed, which is the appeal decision, says that a decision can be appealed to the chief operation officer. Well, that doesn't make any sense in the context of a decision made by the director. Why would the decision be appealed to a lower level official? Same thing with the reassignment procedures under Section 2C. You have a head, it says if a head of component, which the director is not, if a head of component determines that an employee is in excess to the needs of the service, there are various things that have to be considered and various reassignment considerations that have to happen before the employee is terminated. Of course, the director is not a head of component, and it contemplates a process that goes up to the chief operating officer. Again, that doesn't make any sense when you're dealing with a decision made by the director himself. Why would that decision be subject to review by a lower level official? Taken together, the regulations make abundantly clear that although there may be some circumstances where a lower level official makes a determination when these procedures apply, when it is the director himself, consistent with the broad statutory authority that Congress has provided, there is no procedures that apply, and therefore there cannot be a constitutional due process claim as the district court here held.
All right, thank you. All right, Mr. Carroll.
Good morning, Your Honors. May it please the court. I'm Kevin Carroll, and along with my associate, Kira Hama, we represent 19 officers who are facing termination from the intelligence community.
What's their status right now?
They are on paid administrative leave, Your Honors, I think that a critical distinction that's been missed by my friend is that there's a difference between the director's authority to terminate someone on the spot and what post-termination remedies may be. Judge Niemeyer, you hit the nail on the head that the reason why Section 3036, 50 U.S.C. 3036 exists is because there could be a mole in CIA.
Well, it's not just a mole. There's all kinds of reasons. Congress spent a lot of time thinking about the CIA and the ODNI, and those statutes are parallel. And if you didn't do this, you would end up not only a mole, you'd have compromises, somebody who's leaking, all kinds of other things. You don't want to have hearings on this stuff. It's all very secret. The very fact you engage in procedures are problematical. But in this case, the district court got caught up in the procedure that takes a matter, a firing, to the director. And that's the procedure that was invoked. But in this case, it wasn't a lower level firing. The director himself did the firing, and there's no level of appeal in the regulations above him. And he has absolute authority. So that, to me, is the problem with the district court's order. There's just no constitutional issue or APA issue when the director makes that decision. And I don't know what your response to that is. But
sure. I have three responses, Your Honor. First, you're absolutely right. There could be a circumstance, not just a mole, a leak or something like that.
That's all. That's just background for the statute. But the statute repeatedly talks about the absolute authority, the lack of procedure, the unreviewability the director has, and he has to have it. And he exercised it in this case.
Your Honor, it refers to the lack of procedure to terminate, not to post-termination procedures. And you're right, Your Honor. The CIA officers, FBI agents also, for example, are unique here in that they can't bring APA claims. They can't go to the Merit Systems Protection Board. So a due process claim is the only outlet that is available to them. And Your Honor, I think it's relevant that the director referred to a reduction in force, and he referred back to an OPM memorandum that described it as a reduction in force.
Those were the requests that came down, and if you trace the requests, the president wanted this terminated. The OPM, which is the Director of Personnel covering many agencies, issued a memorandum as how to carry that out, and that went to the CIA, and the CIA director refers to this, that this is the wish of the president, and the CIA director exercised his authority to terminate. And his authority is granted by statute. He's not functioning under an OPM regulation. He's functioning under congressional statutes creating the CIA and the OD, Office of
Yes, Your Honor.
Intelligence.
Your Honor, I still think it's relevant that the OPM memorandum is entitled Guidance Regarding RIFs of DEI Officers.
Well, sure. Some agencies have to follow those. Some agencies don't.
Your Honor, the CIA has regulations involving RIFs, and they provide post-termination relief of an appeal to the director and...
Appeal to the director.
Yes, Your Honor.
All right, that's the end line. Now, here, we don't have any action, lower action, that can be appealed to the director because the director made the decision. There is no appeal, period.
Correct, Your Honor. It's not the only right they have, though. They have the right to appeal, which you're right, it's unusual.
And that's what the district court relied on. The procedure wasn't followed and ordered an appeal, and if the record is listened to or focused on, it doesn't make sense that you direct the director of the CIA to appeal to himself.
But Your Honor,
he goes into his office and what does he look at the wall and then say, I stick with my decision?
Your Honor, there was a second right that Judge Trenga referred to, and that's the right to be given an opportunity for reassignment in the organization, and that was critical to the court holding.
You do not have that when the director makes a decision. You do not have that.
Your Honor,
it's irrelevant.
You have it under the regulation regarding RIFs, and the reason why it's inappropriate here for the director to have used this Section 3036 authority.
The director didn't create a rift. The director just fired these people.
Your Honor, I think it's,
OPM talked about it
Because
because
of-
some agencies have rifts that had to do rifts, but the CIA is a special agency, and when the director makes that decision, why would he go through, say, okay, I'm going to issue this to my this officer or that officer to look at this and so forth? He made the decision in this case, which eliminates all of that procedure, which involves an appeal to him.
Your Honor, I think it's important that this Section 3036 authority has never, to our knowledge, ever before been used against more than one officer at once. It's never, to our knowledge, ever been used for other than a counterintelligence purpose.
And here suddenly, an entire office was fired because they worked in diversity and inclusion, and somehow now that is in the interest of the United States, to fire people because they worked in a diversity and inclusion office.
Yes, Your Honor, and this is why a right of review is so important. Some of the individuals were not actually working in the diversity office. You know, one of the appellees was still in the onboarding program at CIA. She was just identified for future onward assignment to the DEI office. Another one of the officers was simply involved in recruiting, not DIA recruiting, just recruiting, as if you're at a law firm, you're doing your responsibilities as a partner, and you might also go recruit law students one day. He was not a DEI officer. None of them, Your Honor, are DEI officers. They're all career
What difference
intelligence.
does that make? He doesn't have to give a reason, and he doesn't have a reason. Doesn't have to have a reason.
Your Honor, he didn't have to give a reason, but he did.
Were
He
you-
gave a reason saying that I'm doing it pursuant to an OPM memorandum.
I
regarding
understand, but
this.
whatever reason he gives is not reviewable because he has full discretion,
Your Honor,
right? I mean, the statute can't make it clearer. I mean, I don't have the exact language, but it repeatedly says that.
yes, Your Honor, and I believe that that discretion is cabined to the emergency situation you pointed out, where somebody
It's
might have to be
not cabined
taken
at
off
all.
the system right at all.
Congress did not cabinet. They didn't even cabinet to national security interest
Correct, although they did say,
in
Your
the
Honor,
interest of the United States. That's the only thing, that, to eliminate the interest of a person.
Your Honor, the Webster Court did cabinet in another way, in that they said that despite Section 3036 authority, the director can't fire people for unconstitutional reasons. He could not, for example, say, I'm firing
Because he's
all
black,
African Americans or all women. And here, they're firing people in derogation of two due process rights. Their property interest under a CARDI of having the agency follow its own regulations, and also their liberty interest in being able to pursue their profession.
What regulation wasn't followed?
The regulation regarding RIFs, Your Honor. But leaving that aside, there's the separate due process claim involving stigma plus. So here, individuals have a liberty interest in
Well,
being able.
firing somebody doesn't create a stigma. Laying somebody off, letting them go unless you say they stole something and made a public thing.
And Your Honor, that's exactly.
Wouldn't the CIA director firing an intelligence officer because he deemed it in the interest of the United States have a stigma to that intelligence officer?
Absolutely, Judge Thacker, and it goes well beyond that. The statements that were put out by the White House about the appellees, that I would take up all my time if I were to read the whole thing off, said that they were engaged in immense public waste, shameful discrimination, dangerous, demeaning, egregious,
Illegal and immoral.
None of you would hire a clerk who'd been described by the President of the United States as having been involved in illegal, immoral, un-American activity. I wouldn't hire him at my law firm either. And that's exactly how these people have been defamed, with a stigma plus claim by the President of the United States.
You didn't sue the president, you sued the director.
Yeah, I thought that there might be some presidential immunity issues involved that are up in the air, but certainly the director that fired them pursuant to this statement is responsible. And we didn't sue him in his personal capacity either. Your Honors, I'd also say that, again, to emphasize, my friend said that the director's authority is totally unreviewable. It's not for constitutional violations. And a constitutional violation is prima facie, represents irreparable harm. As one of Judge Thacker said, The direct CIA director here is saying that his decision to terminate the individuals is informed by, but not in accordance with, the memorandum that refers to RIFs. I
Right,
think,
that's in his declaration before the court, paragraphs 3 and 4.
I think, again, this is a mess of the director's own making. If he's going to refer to a memorandum regarding RIFs and describe things as RIFs, then he has to follow the agency regulations that do exist around RIFs. Your Honor, also in the...
But what about the broad authority that that opposing counsel refers to?
Yeah, sure.
That
Broad
the director
authority-
can do anything he wants without any reason at any time.
Yes, Your Honor, regarding termination, but not involving post-termination rights. And for example, there have been situations in CIA where somebody has been falsely accused of being
All
engaged
right,
in a
so
foreign
you're
conflict.
saying, yes, he could terminate, but there have to be some post-termination rights,
Precisely,
even
Your Honor.
under that broad authority?
Precisely. For example, in the case of a couple of these appellees, the director is saying you're fired because you're a DEI officer assigned to the DEI office. Actually, no, some of them are not. Or to go back to Judge Niemeyer's mole example, somebody could be accused of being a mole. They need to get off of CIA information systems.
He doesn't have to accuse him, and he may just suspect him.
If he suspects it.
And he has a sense, accusing him, even letting anybody know that that's the issue, will reveal information in the intelligence community.
And Your Honor, that officer should have has a right and should have the ability to appeal that determination to the director.
And there's no exception that I read in the appeal provision for decisions that are made by the director himself. The appeal provision, even though it is to the director, I mean, plausibly the director could change their mind. And I imagine there are situations where the director does change their mind even after exercising discretion to terminate an individual.
Exactly, Your Honor. I mean, this court has the authority to make the decisions it wants, and a litigant has the ability to ask you to reconsider that decision.
Are
And
you
it would be the same thing here.
saying that the regulation provides that a decision by the director can be appealed to the director?
Yes, Your Honor. It's basically.
Where's that? I mean, that is nonsensical.
Your Honor, I don't think it's nonsensical.
It's like a motion for reconsideration.
Exactly,
basically.
exactly, Your Honor. And I believe it's section 3036 E2. The director can be asked to reconsider his decision, as would frequently be appropriate when there's been a mistake of fact made, as in the case of some of the.
They could
applicants
ask
here.
for reconsideration, but there was never a request made. The district court relied on a regulation that provides an appeal to the director of decisions made by members of the agency.
Your Honor, it was interesting to me at the hearing in which Judge Trenga denied the injunction. He said, I trust that in good faith, the directors will review their decision and look if there's an opportunity for these officers to serve elsewhere in the individual community. Then the director sent a memorandum, or perhaps it was the Department of Justice sent a memorandum, say, no, Judge, we absolutely refuse to review the decision, and we refuse to consider whether there's any reassignment rights here. And that is when Judge Trenga put in the injunction. So if the government had simply followed Judge Trenga's politely phrased order to reconsider his decision and see if there were other places these people could work, we wouldn't be here today. And again, Your Honor, as far as individualized determinations, one of the appellees is a data scientist. Data scientists are a very hot commodity in the entire economy, much less one's willing to take the pay cut to go into the intelligence community. And when this appellee, when word got around that everybody in the DEI office was going to be fired, 8 other components in CIA offered her jobs, 8. So there was ample opportunity for her to continue to serve her country, continuing on in the CIA. She'd actually accepted an assignment to return to the counterterrorism duties, which she'd previously done. And that's exactly the sort of good faith review and reconsideration that Judge Trenga called for, and I think was a reasonable basis for an
And
injunction.
have any of your clients sought reconsideration or review?
Yes, Your Honor, because the Director of National Intelligence, Director Gabbard, did not send a letter similar to the one sent by Director Ratcliffe of CIA, we did submit requests for review and reassignment on behalf of the 2 appellees who are OD&I personnel, and OD&I said that they'd received it, and then there was no substantive response beyond that.
And that was after the injunction was in place?
That was, I don't want to get this wrong, I think it was between when Judge Trenga said you should give them rights of repeal and consideration, and when the injunction came down. Yeah, it was for sure, because Judge Trenga references it briefly in his opinion, that OD&I had said they were open to appeal and had received an appeal but hadn't acted upon it. And Your Honor, I think Judge Trenga was exactly correct when he pointed to the great expense that the taxpayer goes to recruit, vet, onboard, train, give people experience in the CIA.
He's substituting his own judgment for that of the director. I mean, that doesn't carry any weight.
Your Honor, I think the district judge does have the authority to look at what's in the public interest. He also happens to be the presiding judge of the Federal Intelligence Surveillance Court at the moment. So when it's his view that it's in the public interest for there to be some reconsideration, I think that should be given some weight.
Well, if we affirm the district court here, would we be doing any harm to the director's ability to terminate at his discretion employees in the interest of the United States?
Not only, Your Honor. Not at all.
Why not?
Because we're not contesting that the director has the authority to fire somebody on the spot, just that the individual could come back and ask for that decision to be reviewed if it had been made on the basis of a false set of facts, for example. Or in this case, when they're saying there's a reduction in force going on, but 8 other organizations within the CIA, want the young lady's services.
I am concerned a bit with the breadth of the district court's injunction order, that the district court seems to be requiring the directors to submit termination decisions to the court for approval prior to acting upon them. That does strike me as unusual at best.
Yes, Your Honor, and I think it's because, I can't get inside Judge Trenga's mind, but I think it's because the government ignored, his instructions at the earlier hearing to please in good faith give reconsideration and review.
Where does a judge have the authority to get involved in decisions which could involve the national security?
Judge Trenga does it every single day with the Foreign Intelligence Surveillance Court.
He's not acting under the authority of that FISA. I mean,
Well,
that's a red herring. He's governed by the statutes that govern the director, and the director is given broad authority because of the nature of his job. And to have a district court judge say that he has to consult with the court before he makes a decision seems to me a real interference in the most fundamental executive function of the director.
Your Honor, I'd analogize by saying it happens every day. That there's federal judges that supervise.
You can appeal under procedures that get you to the federal court, but you can't second guess a director who Congress gave authority to dismiss, especially if it involves national intelligence, and that statute involves everything. Involves firing a mole, involves doing everything. It's a
Judge, I'm from New York, and the New York City Police and Fire Departments have had federal judges and federal monitors involving in their hiring and firing decisions, their promotion decisions, police disciplinary decisions.
I wouldn't equate the police department with the CIA director.
They're both involved in life and death national security work, especially in New York City, Your Honor. Your Honor, I think, getting back, to one of Judge Berner's concerns, I don't think there's a risk of the injunction going too far, because one of the things Judge Trenga was careful to do was say that his ruling was limited only to the facts of this case and only to Agency Regulation 14-6. So while this body of 19 appellees is somewhat large, I'll admit, it's not as if Judge Trenga has tried to extend his ruling here to the entire federal workforce or something. It's something that the government has argued here, is that this is just a generic employment law case, and if you find that a party gives a constitutional right to agencies, government agencies following its own rules, that everything will come before the federal courts.
The problem here is that the government is saying one thing and doing another, I think. I mean, even in the declaration of the director before the court, paragraphs 3 and 4 just an inch away from each other. He says, the director says, in order to effectuate the directives of the executive order and OPM memorandum, And the OPM memorandum says that it is, it's titled Guidance Regarding Reduction in Force, and it directs the agencies to execute a reduction in force. And then the director says he's effectuating that directive to issue a reduction in force by just terminating them under his discretion.
Yes, Your Honor, I see my,
I can't.
I see
square
my
those
time's
things.
expired, to answer your question. I can't square it either. And as Judge Niemeyer said, the director didn't have to give a reason. But having given a reason and saying it's a RIF, we believe that it's reasonable that he has to follow
Where did
regulations.
he
for-
say it was a RIF?
He said he was doing it pursuant to the OPM memorandum that describes it as a RIF, Your Honor.
He said, they asked that it be terminated. He didn't say he was doing a RIF, did he?
He did, Your Honor.
He said in paragraph 4 of his declaration, I therefore determined that in order to best effectuate the directives of the executive order and the January 25th Office of Memorandum with respect to the CIA, and the Office of Memorandum from the OPM says it's a reduction in force.
Precisely right, Your
And then
Honor.
he turns around and does the exact opposite.
Exactly, Your Honor. And we'd ask you that the court allow the injunction to stand that these 19 good Americans are
Okay.
allowed to continue serving our country. Thank you.
Thank you, yes. All right,
can't
Mrs. Utrecht?
Thank you, Your Honor. I'd like to start by clearing up a factual misunderstanding. At the time plaintiffs filed their complaint here, there had been no terminations. All the plaintiffs had been put on administrative leave, and no decision had been made to terminate them. And so the fact that the director the next day
Right, that
issued
was
this
all a
memorandum-
reduction in force stuff.
No, Your Honor, they had been placed on administrative leave because their
Right.
office had been closed under the executive order, and there was still confusion about what to do with them.
Mm-hmm.
They were fired or there was an announcement that they would be fired by the director, and in that memorandum that went out on February 18th, the director made the determination, said, I've deemed it in the interest of the United States. Because the director made that determination, that decision, why it was done, is unreviewable by this court. What we're left with here, and again, this is the narrow
But
holding.
I still can't tell, even reading the declaration, why it was done. The director says it was done to effectuate the directive of the OPM memorandum, which was a reduction in force,
The director said,
and then acts like it's not a reduction in force.
so the director in the declaration, again, this is after the original memorandum on February 18th, in the declaration said it was effectuating both the executive order and the OPM memorandum.
Right.
And because of that, he had deemed it to be in the interests of the United States. And again, the fact
And
that
what
he's-
doesn't the OPM memorandum require federal agencies to execute a reduction in force?
So the OPM memorandum, which applies broadly across the board to agencies that do have reduction in force restrictions, which the
I'm just
CIA does
reading
not.
from the director's declaration.
I understand, Your Honor, but again.
That's what he says.
he's-
It's not a very long one. You'd think he could be consistent or get it right in a 3-page, 5-paragraph declaration.
I think the
He
reason
didn't
I'm-
have to say all this in paragraphs 3 and 4.
You're correct, Your Honor.
Because he
All-
does have broad authority, as you indicate. All he really needed to say was that last part, I'm exercising my,
Exactly, and
authority.
that's all that matters.
But that-
Because he said that.
it would have been, but he gave up the reality of what he was doing.
So, Your Honor,
So now we know.
two problems. The first is that by statute, it doesn't matter what the director's motivations are, as long as he has made the determination, it is unreviewable. So then what we are left with is the question of whether the regulations prescribe the director's discretion in any way. And this is where the district court just fundamentally misconstrued the regulation. You cannot ignore the fact that Section 2D of the regulation states that when the director has deemed it necessary or advisable
I
in the
know,
interest
but
of the United
I
States.
also can't ignore that the director himself said that he's effectuating the directives of the executive order in the January 24th OPM memorandum. If he hadn't put that paragraph in there,
So, Your Honor, I think
then it would have
the only
probably
reason we're-
been within his broad discretion.
The only reason we're having this discussion is because the district court thought that if this was a RIF, the procedures under C4 apply. But the problem is that several times throughout this regulation, it says that when the director makes the decision, when it is the director himself's decision, it's an abrogation of all of the other procedures in the regulation, and that he may do so without respect to any of them. And it's not just once, it's 3 times.
No, I understand all of that broad discretion. It's just the way the director describes what he himself is doing belies your argument.
I don't think it does at all, Your Honor.
He's terminating people under a RIF because they worked for a DEI program.
So the only question...
Not because they were spies or moles or
Oh.
anything else, although for sure people are going to think that after the fact.
Just to be very clear, Your Honor, the statute does not require there to be a national security interest for the director to deem
I
it...
understand all that. I understand all
And
that.
if-
I just don't know why whoever wrote this declaration wrote it the way they did, because it's...
And if Your Honor's concern is that you're uncomfortable with the director's motivations for deeming it, I mean, that is exactly
I'm not uncomfortable
what...
with the director's motivations. I'm uncomfortable with the director talking out of both sides of his mouth within a 5-paragraph, 3-page declaration after the lawsuit was filed.
Again, it's not just the declaration, Your Honor. There's also, when the plaintiffs were terminated, they were terminated pursuant to the director's authority, and that happened on February 18th. Plaintiffs haven't disputed the fact that the director made this decision, and the director invoked his authority under the National Security Act, which is an authority that is unreviewable. The only thing that the district court
And I
cited...
understand that, too.
The only thing the district court cited to support the injunction here is the claim that the plaintiffs were likely to succeed on the merits of their claim, that they have a right to reassignment and appeal under the regulation, and they don't. Section 2A...
That was the fundamental
Under the-
reliance. The court cited it both in the injunction and in its oral opinion, Regulation 4-16.
Right.
And 4-16 does not
It does
give
not
them-
do what the district court said it does.
I know, it simply just doesn't do it on its face.
You know, and I know I'm repeating myself here, but Section 2A says that the employees can be terminated without regard to the procedural requirements of this regulation. Section 2D, and that's for all cases, that's not just when it's the director's decision. Section 2D, which deals with the director, says that the director's authority is not constricted by this regulation, that the director's authority is in abrogation of any interest that might be created by this regulation, and also that the director can make terminations without regard to any procedural steps set forth in this regulation. And so all of that suggests that even if you might think that the procedures for reduction in force would apply, they do not apply when the director makes the decision. The CIA could not have been...
And
Were you
consistent with that, the regulation provides the procedure that the ultimate appeal is to the director.
Yes,
And then
it would be-
you've got the clause that you just recited, which the director can do it without any procedure. There's no procedure applicable to his decision.
Right. And so ultimately, I think that the OPM memorandum is kind of a red herring in this case, because what matters for purposes of what the director is permitted to do is that the statute gives him the discretion to make these determinations. He did, and plaintiffs do not dispute, that he did make this determination, and that's
In
not
order to
reviewable.
effectuate the directives of the OPM memorandum.
In order to effectuate the executive order
And the direct, I'm reading from his
and-
declaration.
Yes, he said both, Your Honor, but again, that doesn't change
So
the
it's
fact...
not wasn't a red herring to the director.
So if the director said, I made the
Or
determination
whoever wrote the
because the
directors.
president has told me that he believes that there's national security concerns with this individual, that doesn't change the fact that it is still the director's discretion, and it's his exercise of his own discretion when he deems it to be in the interest of the United States to terminate these people. The motivations don't matter and are not reviewable in this court. The director made the determination, and so all we're left with here is a question of, do these procedures under 2C and 2E apply? And the regulation itself is unambiguously clear. They don't. There is no procedure for, reconsideration or appeal when the director has deemed it necessary or advisable in the interest of the United States. And we're not breaking new law here. That's exactly what the DC Circuit held on remand in Webster versus Doe, when the Supreme Court set down the procedural due process claim in that case. And the DC Circuit held, no, this regulation does not constrain the director's authority. The procedures may apply when lower level officials make these determinations, but it does not apply when the director does. And so that's exactly because the regulation does not confine the director in the way that the district court found, the injunction must be vacated.
All right, thank you. We'll come down and greet counsel and proceed on to the last case. All right. Yeah, we'll hear the next case, unless you want to argue at the next case, too. It's actually sort of difficult case in preparation. All right, we're going to hear next West Neck Community Association versus JBWK. And Mr. McIntyre, whenever you're ready, we'll hear from you.
Thank you, Your Honors. May it please the Court, John McIntyre on behalf of JBWK, the appellant and cross-appellee in this matter. Your Honors, the declaration in this case,
I think you probably need to pull the microphone up a little bit, at least for me. Thank you.
My apologies. The declaration in this case, although it's a long document, structurally is very simple. The declaration starts with...
That's the wrong statement to make. It's got some inherent inconsistencies, and I've read the whole document in several parts multiple times. And you rely on one section that sort of protects declarants from certain things, but there are other sections that seem to suggest that the restrictions on land use and commercial use apply to everybody. And so the district court read it that way, and be interested in hearing how you address that.
Yes, sir. Except with regard to, I will say this, except with regard to the rules and restrictions, which we did not challenge the district court's decision that those are limited to residential, recreational, and related uses, because frankly, that there was no need to challenge that. The remainder of the provisions, I would suggest, are not contradictory. And that's because the introductory sections of the declaration start very broad. They use broad terms like all property shall be owned, conveyed, and used, subject to all provisions of the declaration.
What's wrong with that?
Nothing, Your Honor, except that the operative provisions of the declaration do restrict those provisions to certain classes of property or certain people. And taking it outside of the context of the appeal, look at membership interests. The introduction states that all owners of real property are members of the association. I believe the quote is, the association is comprised of all owners, small o, not large o, of real property in West Neck. 7.3 defines membership interests in the declaration. 7.3 says there are two classes of membership interests, Class A members and Class B members. Class A members shall be all capital O owners, except the Class B member, if any. The sole Class B member shall be the declarant. So the introduction uses broad terms saying it applies to everyone. The specific provision dealing with membership interests limits that to capital O owners and the declarant. That's the structure of the declaration.
There is a section here called 6.1 that says maintenance of units and private amenities.
Yes, sir.
And the private amenities, of course, is a golf course, right?
Currently, it would be a golf course, or we're using it, frankly, for
I
walking
understand
trails
now
and
the
the
land's
like.
being used differently, but it's that golf course land.
Yes, sir.
Okay.
That's correct.
And in that, it says, each owner shall maintain his or her unit or private amenity respectively, and the key thing is here, and all landscaping and improvements comprising the unit or private amenities in a manner consistent with the governing documents. Now, your argument is that the first use of the word owner is capitalized and therefore refers to a unit owner, and that's absolutely correct. But then it adds, it uses that term, or sort of repeats it. It says owner of a private, implicit is owner of a private amenity. And that is left out. So it says owner shall maintain his or her unit or private equity. And it should be, if it were grammatically more correct, it should have used lowercase owner, because that capital is a defined term. And capital, it means owner of a unit. But then it says each owner shall maintain his or her unit, or the owner of a private amenity shall maintain this in accordance with the documents. But the title of the whole thing talks about maintenance of units and private amenities. That's 6.1, and then 6.2 is maintenance of neighborhood properties. And what it tries to do is cover all the properties to say they have to remain consistent with the declarations, the documents on file.
I would disagree with that, Your Honor. There's
Okay.
nothing in the definition of private amenity that, one, limits it to the golf course. So, for example, their condominium.
It doesn't matter whether it limits it. The golf course is a private amenity, isn't it?
The golf course was a private amenity, Your Honor.
And so the private amenities have to be maintained in accordance with the declaration documents.
I would disagree with that, Your Honor. The term owner describes the individual who owns either the unit or the private amenity. There's nothing in the declaration that prohibits an owner, that is, someone who owns residential units, such as Baymark Construction, when it owned both the golf course and the entire development, the various neighborhoods, from being a capital O owner of both a unit and a private amenity. I think trying to insert a small o owner into that sentence is rewriting that sentence.
Well, if the only person that was in that circumstance was the declarant who owned both.
That would be correct in that instance, Your Honor, but I would
Or at
suggest.
any instance. I mean, the fact is that you would have to have a peculiar circumstance where the declarant, well, who else would it be?
Your Honor, the way this development was constructed, Baymark carved it up into various parcels, various neighborhoods, and sold those off to other developers in certain circumstances. So if I'm developer A who acquires a part of that property, and I construct some homes, and let's say it's a condominium, because there are condominiums in here, and I include a small park, that's going to be a private amenity.
Except that, where's the, I'm not sure. That's a pretty strained hypothetical when you have the owner who did own some units and who owned the private amenity, and the only private amenity was the piece of land on which the golf course was lying. And I just use that for identification purposes, not as a golf course.
Sure.
But the question is whether that land is subject to the declarations. And not only does the introductory document say all property is subject to the amenities, but then the maintenance clause says the same thing. And the declarant happened to be an owner of both unit at that one, of all units actually before the first one was sold, and the private amenities.
And then it transferred it, Your Honor, to a non-owner, Baymark Golf. And that's the purpose of that section. It allowed the declarant to do that.
Well, that person who took away from the original declarant still was responsible for all the obligations imposed on the first declarant. The first declarant was the owner of the units and the private amenity, right? First declarant was the developer.
The first declarant was the developer, Your Honor.
Okay, the developer owned units he was trying to sell, and he owned the private amenity, the land that was then designated as a golf course.
That's
He owned
correct.
both.
That's correct.
And that clause clearly applied to him, right, at that point?
Well, at that point, yes, it would have
Okay.
applied to him.
And so now, as time goes on, he sells that, or he sells his interest to another declarant, but I don't think any subsequent declarant can gain more rights than the original developer had.
Again, and I don't think it's a question of gaining more rights under 6.1A, Your Honor. The court is, Your Honor's hypothetical inserts into that section, that sentence, an additional provision. Any capital O owner must maintain its unit, and then the court's inserting, and any small o owner must maintain the private amenity in accordance with the governing
Well,
documents. It's rewriting that sentence.
That's not rewriting the sentence, because the declarant did own units before they were sold, and, but the next sentence, next clause says, and all landscaping and improvements comprising the unit or private amenity in a manner consistent with these declarations.
And as the district court pointed out, under the private amenity sections, the association is not allowed to impose landscaping requirements on the private amenity.
It's not the association, it's the documents, the exhibits to the declaration which provide for the land use is what's applicable.
Well, the provisions
What's
which
it, number
reply
C?
to...
Exhibit C? Or?
Exhibit C, Your Honor, is not the community-wide standard. Exhibit C is the rules and regulations.
What
That's
about-
governed by Section 4.
Which one's the regulations of uses?
That's Section 4, Your Honor.
What about Article 17? Article 17 governs private amenities, which I assume includes, at least the golf course was a private amenity. I don't know if now it's, my understanding is there is no private amenity on your client's land at this time.
Technically,
It's
the
undeveloped
district court-
land.
Oh, I apologize, Your Honor. Technically, the district court found there was a private amenity. We're allowing certain residents to walk on the trails, the...
Oh, and there's a
golf
wedding
paths.
venue, right? Isn't there also a wedding venue?
Yes, Your Honor. There's a wedding venue in the clubhouse. The clubhouse is renting out the wedding venue company is renting out the clubhouse and the associated parking, as well as a small portion.
And so in Section 17, the general section, it seems to provide broad discretion for the owners of private amenities shall have the right from time to time in their sole and absolute discretion, with or without notice, to amend or waive the terms and conditions of their respective private amenities, including without limitation. I mean, it seems like under this section, those owners of private amenities can kind of do whatever they want with their land, or at least change the conditions.
That's true, Your Honor. And in fact, that also echoes 10.3, which deals with supplemental declarations. Under 10.3, the declarant is entitled to execute and record a supplemental declaration, either expanding or restricting any provision of the declaration. So again, to say that 6.1 is limited and therefore must always track with a private amenity, a supplemental declaration can fix that. And that's even acknowledged in the second half of the first sentence of 6.1, where it references that the association with respect to a unit has to maintain the unit if it's in a supplemental declaration. Again, something that 10.3 expressly provides for.
And 11.3 also provides a right to develop to the declarant.
That's correct, Your Honor.
And the district court determined that your client is the declarant.
That is correct, Your Honor, and the assignee of the declarant rights. There's two separate concepts. The being the assignee of the declarant rights themselves is not really an issue in the appeal. Whether we are the substitute declarant is an issue that has been raised by the association.
It has been raised?
They've raised the question of whether we are truly the substitute declarant. They have not challenged the fact that we took an assignment of the declarant rights under 11.7. I would argue it's largely a distinction without a difference, because under Virginia law, an assignee steps into the shoes of the assignor as if they were the original party under the contract.
You would agree that any transferee carried the obligations, assumed the obligations that the initial declarant had?
Oh, absolutely.
Yeah.
Absolutely.
Yeah, I thought so.
I don't think the assignment of rights allows for a restriction of those rights. I would point out 10.3 does allow for a restriction of those rights through a supplemental declaration. Your Honors, that's essentially our position in this case.
Can I ask about the ADR procedures? Did anybody, why weren't they complied with here? That's a condition precedent in the contract that the parties comply with the ADR in the contract, and it doesn't seem like either side is adequately complied.
Your Honor, we tried to. The record is clear that we attempted to schedule mediation. We had intended to plant more trees on the property. We had several trees on there. That was the subject of the first lawsuit. The first lawsuit was non-suited. And then we wanted to plant more trees on the property. We wrote a letter saying, we'd like to plant more trees. Let me know if you have a problem with that. I actually scheduled tentatively mediation through McCammon Group. The association's position was that it didn't want to go through mediation, which it's entitled to do. There's nothing wrong with them taking that position.
But as I understand the contract, if they take that position, then they can't assert their rights.
I would not agree with that, Your Honor. Honestly, I think the way the ADR provision works is if you raise a claim, if you provide that notice of a claim, which is a preliminary requirement, and then you don't go to mediation, then you waive that claim. But that's the only time waiver really occurs. So they, as the respondent, if you will, to our request that we wanted to plant more trees, they're entitled to say they don't want to go to mediation.
Well, that's a little euphemistic. You wanted to plant the trees to sell them. You wanted a commercial operation.
We did.
Okay.
We did, and that's part of
And
the
a commercial
problem.
operation is prohibited by the use.
Strictly it is, Your Honor, and that's one of the issues the district court raised. A golf course
I
is a
thought that's the
commercial
whole
operation.
issue here, is whether the property where the golf course was is subject to the restriction against commercial use.
It's not so much whether it's subject to or not, Your Honor. Again, it's the structure of the declaration, and it's not the most elegant, no question. But, Your Honor, if you look at 11.3, 11.3 says that any owner of property in West Neck is prohibited from challenging a change in use of property at West Neck. Unless
That's any owner. It doesn't say anything about the association.
the association is an owner, Your Honor. It was undisputed they own the common areas. It wasn't capital O owner. That's a small O owner, and they are a small O owner. So the association is an owner of property in West Neck, and that section says you cannot challenge a change in use unless your property and the subject property are in the same neighborhood. And it was undisputed our property is not in a neighborhood. Again, that's the structure. I'm not saying it's an ideal structure. I'm not saying it's even a good structure. But that's how it was drafted, to give Baymark the maximum flexibility to do what it needs to do. I see my time is up, Your
Yeah,
Honors.
all right.
Thank you.
All right, we'll hear from Mr. Baumgartner.
Good morning, Your Honors. My name is Mark Baumgartner on behalf of West Neck. Judge Niemeyer pointed out at the beginning that this is a convoluted document, and I've had the misfortune actually of litigating this document twice in two different communities that used almost the exact same document by the same.
I gather you didn't draft it then.
I did not draft it. The document was drafted, I am told, by the same law firm that drafted the documents for Disney World's developments, and the developer thought that's a good drafter. It is a very convoluted document, and even though I've litigated it twice, I repeatedly go back to provision after provision after provision. I think that the most helpful provisions in this case are the introductory provisions that make it clear that the purpose of this document is to create a cohesive community that is subject to a community-wide standard to create a development that people can live in and be pleased with. And that applies to all properties. And I think the reading of 6.1a, where it specifically says that the owners of a unit or a private amenity clearly intends that a private amenity is going to maintain its property in accordance with the community-wide standard. Yes, there's some latitude in perhaps the exact way it's going to do that. A golf course is going to be maintained in a different way than a residential unit, but nonetheless, both need to be maintained to the community-wide standard. And so I think the district court was absolutely correct in that regard. In addition, the JBWK concedes that Exhibit C, the rules and regulations apply to all properties, and Section 1 of Exhibit C talks about that it must be restricted to residential and related uses. But Section 3 of those restrictions specifically also says that, and this is on page 128 of the Joint Appendix, subsection 3, prohibited conditions, the following shall be prohibited at the properties. That's all properties, not all owners, not capital O owners, not lowercase owners, at the properties, and JBWA they concede that they are part of the properties. Plants, animals, devices, or other things of any sort whose activities or existence is in any way noxious, dangerous, unsightly, unpleasant, or of a nature as may diminish or destroy the enjoyment of the properties. And that absolutely demonstrates that the intent of the document is clear. And I believe it was Judge Berner that pointed out Section 17 that applies to the private amenities. And 17.10, in fact, imposes an affirmative obligation on private amenities. And it says, private amenities shall cooperate and assist the association in maintaining the community-wide standard. So I think it's disingenuous for a private amenity to say, yeah, we're going to cooperate and assist in maintaining this community-wide standard, except for our property, we're going to let it grow up in a bunch of weeds, and we're going to, around the edges, we're going to put up a spite wall. If you complain, we're going to put up a wall just in front of your house, not your neighbors, because they didn't complain, and we're going to grow a tree farm on this property. Those are not actions that are consistent with the requirements of Section 17.
Was there a prohibition of commercial activities? I thought there was, but I may be wrong.
There is. It's in Exhibit C.
Exhibit C. JA 125 and 127.
Thank you.
Yeah. Thank you. Yes, 125, 127 restricts that. In addition, there's also restriction on violations of zoning. And it's in the record that this property was rezoned subject to proffers, and the proffers required that the property be developed in accordance with the master plan, and the master plan shows a golf course on this property. It doesn't show a tree farm. So the operation of a commercial tree farm would also violate the zoning proffers, and the rule Exhibit C prohibits anything that violates zoning and allows the association to enforce the declaration in that regard.
What about the provision that allows for amendments?
Yes, Your Honor, the amendments, so there are amendments allowed, and so long as the declarant owns property within the community,
Which it does.
the declarant's consent is required. But in this case, Baymark, who was the prior declarant before attempting to assign its rights to JBWK, no longer owned any property within the community. As has been noted, the golf course had been conveyed to a different entity, Baymark Golf. The declaration did not, the Baymark did not assign declarant rights to Baymark Golf. And so Baymark no longer owned any property within the communities. Therefore, Baymark's consent was not required. What JBWK is trying to do is resurrect dead declarant rights.
Well, the district court found that JBWK is the declarant. If we agree with that, then wouldn't the declarant have the right under the agreement to make any amendments, including to this provision regarding commercial development or businesses being operated on the property?
I understand the question now, Judge Berner. The declarant can make certain amendments, but I don't believe that the scope of the amendments that would be allowed by the declarant would allow the declarant to change those provisions.
Where does where's that limit found in the document?
The limitation is, with regard to the 10.3, I believe addresses property that is added to the community, and the time for the addition of additional properties has passed. And then there's no other.
Well, 10.3 talks about properties with capital P, and then properties are defined to include, I believe, the property that is at issue here. So it says declarant may subject any portion of the properties to additional covenants and easements, including covenants obligating the association and additional covenants and easements. It just seems incredibly broad to me that the declarant essentially can make changes.
It does. And then it says, at the last sentence, any such supplemental declaration may supplement, create exceptions to, or otherwise modify the terms of this declaration as it applies to the subject property in order to reflect the different character and intended use of such property. So there are certain limitations on that. And the fact is that the declarant did not make any amendments. So there, as far as amendments subject to 10.3, they're not before the court. The declarant did not make any amendments, and the question is not whether it can in the future. It has not made any. And our argument on the cross appeal is that the district court erred in finding that it was a successor declarant. At no time, first of all, there's two reasons for that. First is that in order to be successor declarant, the property has to be obtained for the purpose of development and or sale. That's a specific purpose for the acquisition of the property. And in the deposition of the designated representative of JBWK, he testified that when WCC Capital first purchased the property, it was going to quickly sell the property, maybe to the association, maybe to somebody else. So there was a speculative, is what he said. There was no distinct plan, but it was speculation. Then, however, they decided to start this farming operation, and JBWK was initially just the lessor. It was leasing property for the purpose of running this tree farm. They then did a merger, and I think it's significant that the successor in that merger was the operating entity, and that's what JBWK's representative testified. That as we've learned that we were going to be here for a while, we decided to have this operation of a tree farm, running a tree business, and we merged into the operating entity. That's what the deposition said. Now, later in summary judgment, they did declarations and then said, well, the property was still up for sale. But I don't think the declaration really contemplates every property is for sale at some point. There's an old saying, everything's for sale, just has to be the right price. But the fact of the matter is, after the merger with JBWK, the purpose of JBWK was to operate a tree farm. After that, they had no other plans. They were talking to people. They were doing all kinds of things. But the operation of JBWK was a tree farm. And on summary judgment, the court recognized that there was a conflict regarding that essential fact, and on summary judgment resolved that conflict between deposition testimony and an affidavit, quite self-serving affidavit done by the JBWK's representative and JBWK's owner, Chris Coleman and Mr. LeClaire, that said, oh, well, our purpose was to sell it. That's not what the deposition testimony was, and I think that's the type of credibility determination. When it comes to determining intent of a party, it is particularly ill-suited for resolution in summary judgment.
I don't understand why that makes one hill of beans difference. Seems to me that if JBWK, whatever their purpose was for organization, merged with a person subject to the declarant obligations, that corporation is going to be subject to the declarant operations, at least with respect to this property. Now, they may want to operate tree farms in other towns and other places, but it's just an assignment, as the district court found, it's just an operation of law. You merge with somebody, which is a declarant in this case, and that declarant has obligations with respect to this property. And so he's going to be bound by whatever this property requires. He can't succeed to more. And the argument is, well, he's organized to operate in a commercial property, but sure, he may be organized to operate a commercial property, but he can't operate it after he assumes those obligations in the merger.
Certainly, he doesn't rise above the level of the declarant.
No.
Under no circumstance would that
And that's
successor.
what the district court found. It just basically, it's a legal succession of assignments of declarants' rights and obligations. And the end of the line was JBWK, and there's no dispute, they don't dispute the fact that it is subject to the benefits and obligations of the declarant.
They certainly don't dispute that the property is subject to the declaration.
No, I'm talking about whatever rights the declarant has or whatever obligations the declarant has are imposed on JBWK. And that to me is a non-issue in the case.
Well, that is an issue on our cross appeal because we dispute the fact that
I know you dispute it and I don't understand it.
Okay. And the reason for that is that the declaration requires two things for someone to be a successor declarant. They have to hold title to property in the community, and they have to be identified as the successor declarant in the recorded document. And in this case, when there was first a purported assignment of declarant rights done in November of 2021, and that assigned declarant rights allegedly to JBWK by a defunct corporation. Baymark was the original. They they terminated their existence in 2020. And so they were no longer the declarant. They no longer owned any property in the community. At that point in time, the trustee in liquidation purported to assign rights of this defunct entity to JBWK, which also did not own any property.
Does JBWK, do they own the golf course land?
They do now, but they did not when the rights were first assigned.
Well, they do now. They succeed as a property owner. The owner of that amenity, they're subject to whatever this document provides, aren't they?
They absolutely are subject to whatever the document provides.
Yeah.
Our argument is that they don't have the super declarant rights that
Why not?
died in 2020 when the Baymark terminated its existence.
I don't know
Does
why not. Where was there a reduction in any rights? When you assign a land, assign property of land subject to these documents, then you are the declarant.
But the declarant, the amendment provisions in the declaration
But
say.
there's no amendment made, you said. It's irrelevant.
The association did make an amendment in August of 2022 in recognition of the fact that there was no declarant. And the declarant right, the JBWK has asserted that the declarant has a right to consent to any amendment. However, that right only survives so long as the declarant owns property that are subject to the declaration. So once the declarant no longer owns property subject to the declaration, its consent rights went away, and that happened in 2020.
Okay.
So I'd like to reserve the rest of my time.
Yeah. Thank you. All right, Mr. McIntyre.
Thank you. I'll try and be very brief. First, I disagree with the association's statement that Baymark does not own any property in the covered by the declaration. The affidavit of Pay and Faber, which is found at JA 765, which was our expert witness, indicated that it owns, among other things, Riddick Lane. If you look at Exhibit A to the declaration, which defines the capital P properties, that includes Riddick Lane. So Baymark does still, it's a spur piece, but it still owns property which is subject to the declaration. Your Honor, getting to your question again about 6.1, looking at it another way, the community-wide standard, and this is at JA 59, the community-wide standard is defined as the higher of the minimum standards, which is the architectural guidelines, the restrictions and rules, the resolutions and examples of the board and the declarant, or the prevailing standard. So the architectural guidelines are part of the community-wide standard. 5.1 says the architectural guidelines do not apply to the declarant's activities.
Yeah, but we're not talking about architectural. We're talking about the use, commercial use provision.
Your Honor, we don't
in the
dispute that.
rules, in the rules, and that's not covered by the architectural, is it?
The architectural guidelines govern things like fences.
I understand, but
And
we're
whatnot.
not talking about that. We're
That's-
talking about the rules and, what is it entitled? Rules and,
The rules and regulations,
Yeah.
we didn't challenge on appeal, Your Honor.
Yeah.
We did not challenge the district court's determination of what those mean. The
I
question is whether
understand,
or not the
but you just
community-wide
cited a
standard.
provision which referred to the architectural, and I'm saying that's irrelevant to what's before us.
Well-
What's before us is the declaration, the rules and regulation, which are part of the declaration documents.
I would contest that, Your Honor. The 6.1 is the community-wide standard. And the community-wide standard includes the architectural guidelines.
I know.
So to say that the declarant is subject to the community-wide standard is saying that it's subject to the architectural guidelines when those guidelines say they don't apply to the declarant. And that's why 6.1 has to be interpreted the way it's written, and that is owners of units in private amenities.
You're trying to claim an exception to the architectural things, but that provision does not address rules and regulations, which is a separate document.
I would agree with that, Your Honor. Again,
Okay.
I was only
And so-
addressing 6.1. 6.1 doesn't involve the rules and regulations.
6.1 says the whole declarations, doesn't it?
It's the maintenance. 6.1
Right.
only deals with
In a-
maintenance of property. And, Your Honor, that is limited to
In a
owners.
manner consistent with the governing documents. And the governing documents include the rules and regulations, right?
That is true, Your Honor.
All right, well, I don't know how that could be clearer.
But, Your Honor, I would suggest the use of the capital term "O" could not be clear either. And I
Well,
would simply note, that's the maxim.
There's two answers to that. Number one, there's two other indicators. First, the whole title to the section is maintenance of units and private amenities. And then the second is that the unit owner is capitalized, and they want to describe that, but they also then added private amenity, which is not a unit owner situation. They probably should have added an owner of a private amenity, but that is but what indicates further is that the next clause talks about all landscaping and improvements shall be subject to the documents. And it seems to me it's clumsy. I agree. You have that argument, but it seems to me the district court read it in this way, which only way it can make sense.
Well,
I mean, they're addressing maintenance of units, and private amenities.
Of owners, Your Honor.
No,
Again,
it
I would
doesn't
just.
say that in the title.
It
And then
does
it
not say in the
describes,
title.
it describes that below.
It does say it in the substance, Your Honor, and with the section Judge Berner pointed out, it says landscape in the section you were referring to. Private amenities are excluded from control over landscaping. So, Your Honor, the only way to make it make sense is if you say it's an owner who has either a unit or private amenity, and I'm going to mangle this because I did not take Latin in high school, Your Honor, but the maxim expressio unius est exclusio ulterius, which is accepted in Virginia, means the exclusion of one thing implies, the inclusion of one thing implies the exclusion of others. When you use the word capital O, owner, at the beginning of the sentence, then that applies grammatically to the rest. Private amenity is not set off by commas. It is the owner of a unit or private amenity.
I know, but what the drafter wanted to use, owners of units and owners of private amenities, and wanted to use the one subject. With respect to the units, it is a capital O. With respect to the private amenities, it's a small o. But it's at private amenities, units and private amenities are governed by it. And it says in the very next clause, all units and private amenities are subject to the.
Again, I would disagree, Your Honor. It says each owner shall maintain his or her unit or private amenity. In that sentence, structurally, owner modifies unit and private amenity. And if we're going to insert an additional clause, each owner shall maintain his or her unit or a regular owner's private amenity, small o owners, we're rewriting the sentence. And that's something Virginia law does not allow, Your Honor. I see my time is up. I do thank the court for its time.
What, do you have some rebuttal time here because of your cross appeal?
Yes.
Yeah, all right. How much time did we reserve for you?
5 minutes.
Okay.
And I want to focus on the question regarding the mediation and also the district court's finding, the mediation ADR provisions, and also the district court's finding that the due process requirements under the bylaws were not followed, and therefore the association could not enforce, in this case, the violations that it found. First of all, and I want to be very clear here, there was a mediation regarding the maintenance of the property and planting of trees by JBWK that occurred at a time before there was any assignment of declarant rights. And it was JBWK that was planting trees, and they were not maintaining their property. And at Joint Appendix 47 and in JBWK's reply brief at page 50, they concede that, and they stipulate that they did attend a mediation regarding the tree issue and the maintenance of the property generally. There's also in the joint appendix that the association did hold a due process hearing, and JBWK attended that due process hearing. That's at joint appendix page 685, also at 14 and 44 in the complaint and the answer, they admit the allegation that they attended a due process hearing. Furthermore, section 8.4 of the declaration, joint appendix at 85, provides that this is in section 8.4 at the top of page 85. In addition, the board may take the following enforcement procedures to ensure compliance with the governing documents without the necessity of compliance with the procedures set forth in section 3.24 of the bylaws. And Romanet 2 of that section says, bringing suit at law or in equity to enjoin any violation or to recover monetary damages or both. And so the action by the association in this case for JBWK's failure to maintain the property and by planting trees in violation of the declaration, which as the court found was a violation of the declaration, but the district court held that the association was not allowed to enforce that because it had not complied with the bylaws. Section 8.4 specifically allows the association to undertake that without complying with the bylaws, number one. And number two, JBWK admits, and the record is clear, that there was a due process hearing held. JBWK did appear to that as part of the due process under the bylaws. So the district court erred in not allowing the association's enforcement action to proceed. When it came to the mediation, and in the record, there's some exchange of emails that are at page 537 and 530 of the joint appendix. And that was broached with the topic of, hey, we're going to plant more trees. And the email said, does the association still contend that planting trees, it violates the declaration? And we responded that, yes, we still take that position, and we don't need to mediate that again because we've already mediated that. And the district court, in its opinion, found that the other issues were also in dispute, and that's at page JA 962, but the record does not show that there was any communication between the parties regarding JBWK's contention that that they were the declarant, that JBWK disputed the amendments to the declaration, and in fact, at JA 35, JBWK admits that prior to it filing litigation, it never raised those claims to the association. So with respect to the mediation condition precedent, and the email exchange is also clear that both parties were waiving the mediation as to the tree maintenance issue, but they were reserving their rights as to all other issues, and those other issues were never presented as claims prior to JBWK filing suit in the federal court. And so to the extent that the mediation provision applies, which we believe it does, it applies to the new claims asserted by JBWK that the association's amendments were invalid and that it was a declarant. Thank you.
Okay, thank you. Will, do you have anything further? No. I don't have any further. Yeah, okay, thank you. We're going to adjourn for the day. We'll come down and greet counsel.